just to let everybody know, I've been selected as the chairman of the board for this evening, and we'll start off with Pledge of Allegiance, and then we'll get into everything this evening. Has either side selected who will be starting off this evening?
Mr. Rice, if you're ready, if you'd call your first witness, or opening.
Used to the handheld mic. Okay. Good evening. John Rice here for Radnor Township. What you have in front of you is a violation of the Township's rental housing ordinance, March 27th, 2012 letter suspending the student license for 54 Garrett Avenue. Mr. Miller is here to testify. I also intend to call Chief Colarulo and other members of the police department who have some history with this particular property. What you're going to hear, notwithstanding Mr. Flaile's appeal, is a long history of violations on this property that go back to 1999. Same owner, they're here tonight. Same property manager, they're here tonight. This has been going on since 1999. So despite the appeal that's been filed that Mr. Liotta has always abided by the township's ordinances, you're going to find out tonight that he has not. And that this is the first time that his license has been suspended, but it's not something that was done lightly. It was done after a long history of violations of this ordinance, and in particular, since last fall. So with that, unless Mr. Flaile has any opening comments, he's the appellant here.
I'm going to reserve the majority of my comments till the end of the hearing, but just based on what Mr. Rice said, keep one thing in mind. Regardless of whatever else you hear here tonight, the reason for the suspension is the incidents that occurred in October of last year and March of this year, not what happened 10 years ago, 15 years ago, or 5 years ago. That's what the notice says. We can't expand upon that at this juncture.
Okay. I'm going to call Mr. John Liotta as of cross. Going right up here.
And sir, before you seat, if you could raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
And state your name and spell your last.
Cool. John Liotta.
And spell.
Liotta.
Okay, Mr. Liotta, what is your business address?
The P.O. Box?
Do you have a street business address other than the P.O. Box?
No.
Okay. You're the owner of 54 Garrett Avenue, is that correct?
50% owner.
Okay. And the other 50% is who?
Executive Property Management.
And who is or what is executive property management?
Ben Sprango.
Is he the only shareholder?
Yes.
Okay. You have any interest in that? Okay, but you have an individual interest and he has the other 50% interest?
Correct.
In ownership?
Co-ownership.
Okay. And how long have you, have the two of you owned this property since 1988, is it?
Yes.
Okay. Do you own or executive property management own any other rental units in Radnor Township?
He might, the executive property manager might own some.
Okay.
Yes.
But you do not?
I do not.
Okay. Any other municipalities? that
Yes.
Where else do you own rental units?
Bryn Mawr, Lower Merion, Haverford.
And these are all single-family dwellings or twins?
Correct. Correct.
Are they all rented out to students also?
No.
And who actually manages these properties for you? Do you have a,
It's a joint venture.
so the two of you
Yes.
take care of complaints
Yes.
jointly?
Mm-hmm.
The two of you decide whether to fix something on this particular property or not?
Correct.
If it needs to be painted, you decide together?
Yes.
And what about trash or other problems that occur on your rental units? Do you take care of those?
Yes, if required it, yes.
Okay. I just want to talk about 54 Garrett because that's why we're here tonight. The township received a lease. There's a lot of feedback on this. Mike, a little bit too close. Does it work this far away? Okay. Mr. Liotta, the current lease on this property was a lease that was entered into between you and two individuals, Marissa Brown and Maureen. Do you know Maureen's name? No? Do you have a copy of the lease with you here tonight?
I think my attorney does.
So I'd like to identify that. Can we mark this as T1? It looks like the other lessee's name is Maureen Mutual, M-U-C-H-E-L.
That's correct, yeah.
You have
Mr. Rice, I'm
lease?
sorry, that last name again?
There's no landlord signature on this lease, is there?
It's our manager. I didn't sign the lease.
And who's the manager that signed here?
Ben, who do we, because we have administrative people, so I don't know who signed.
It looks like Andreas Cosma. Does that sound right?
Yes.
Gentlemen, if we can, only the witness can be testifying, but I understand these some preliminary issues, but let's try to keep that to a minimum.
Okay. And that individual works for you?
That does not work for me, no.
But
Work.
they're signing here. He can't answer the questions.
The person does not work for me.
Is it fair to assume that individual works for Executive Property Management as an employee? Do you know?
I don't know.
Okay. You familiar with his lease?
Yes, I am.
Okay. On the signature page of the lease, paragraph 83. Could you just review that for me for a minute? It's entitled Student Ordinances.
Yeah, this particular, I guess, this particular lease, because we have so many properties, some are not student approved, and this ordinance was, I guess, mistakenly left in there about that.
Because this does say that lessees, in this case, Ms. Brown and Ms. Mutual, represent the lessors, that they're not students as defined in the zoning codes of the applicable township. And that representation, is that in all your leases?
No, this is for whatever reason on this particular lease.
But these two women were students, correct?
Correct, that is correct.
And you're aware, Mr. Liotta, that in Radnor Township, the Radnor Township housing ordinance permits 2 students
That's correct.
Right.
Yes, I am.
And you've been cited on more than one occasion for having more than 2 students at this particular address, correct?
I don't recall being cited for that.
Do you recall being in District Justice Court with me in December of 2010 and
Yes.
paying a $1,000 fine?
Yes.
And that was for having 5 students at that time, correct?
I don't know the number. You were talking about trash. We never even got to the judge. I just paid the $1,000 fine.
But you remember being there with me and Matt Bauman, who was the
Yes, I
code
do.
enforcement officer at
Yes,
that
I do.
time, right?
Mhm.
Mr. Economides, I want to mark another document as T2, if I could.
You can give me a second to have the court reporter catch up. I don't think that we actually marked the first one either.
You can just mark it, I'll do it afterwards, so we don't take time.
Mr. Rice, you can continue. Do you want me to hand this to the witness?
Yeah, I would like the witness to look at this.
Take that first one back.
Okay, thank you.
While he's reading, I'm going to object to the use of this document and evidence because it goes clearly beyond the scope of the,
Mr. Flail, could you use the microphone, please?
sorry. I'm going to object to the use of this document because it's clearly beyond the scope of the violations included in Mr. Miller's notice of the suspension. And if he didn't base his decision on prior occurrences, he can't use it in this hearing.
Well, if I can just respond to that, Mr. Flail, in his appeal, states that there's never been any problems or ever been any violations of the ordinance by his client since his client has owned the property in 1988. There's certainly part of this appeal, and it's in the record, the April 10th, 2012 appeal, is that Mr. Liotta has been an upstanding landlord and there's never been any issue. So I don't think that I think it's relevant for this board's consideration, and the past conduct of this particular landlord is appropriate.
And Mr. Flay, that would be my recommendation to the board, is that,
Well,
that it,
you're talking about two different things here. This only has to go with the credibility of the witness, and as far as the statement in the appeal about the rental housing ordinance, this ordinance was only passed in 2011, so anything prior to that wouldn't be relevant to this proceeding anyway. If he wants to use it for credibility, I don't have any objection to that, but we're not going to expand the scope of the reasons for the suspension beyond what's stated in the notice of suspension. You can't do it, period.
And that's not, we're not trying to do that. I'm responding to what this particular applicant has filed on his appeal, that he has not violated the ordinance in the past.
I understand the objection. Mr. Rice, I want to make it clear whether or not you are limiting this, though, to credibility. I didn't think you were limiting this to merely his credibility.
I'm not just limiting it
yeah, I
to
didn't think so.
credibility, but it's up to this board to decide whether or not the notice of violation is supported.
Well, I do think, I mean, to cut to the chase, my recommendation to the board is that it is relevant. I think that, it has been raised by the appeal, and I think the ordinance certainly takes that into consideration in history of the property. So with that, I would recommend that the board could overrule the objection and allow the evidence in.
Please note my continuing objection.
Yes, sir, Mr. Flay. Your objection is noted on the record.
Okay, Mr. Liotta, what's been marked as T2 is a 3-page exhibit. The first page, would you agree, is a non-traffic citation issued to you in 2010?
Yes.
okay? And that is landlord, it states on the face of it, landlord is in violation of Chapter 226-7 rental housing. Student contains 5 occupants, correct?
That's what it says, yes.
Okay. And down below that, there are 4 names listed on this exhibit. There's a Robert Fitch, there's a Kara Fitzpatrick, there's a Stephen Jeffers, and there's a Paul Schifano, correct?
That's what it says, yes.
Do you know if any of those had leases with you at that time?
Kara Fitzpatrick, I think.
Okay. But none of the other ones had leases, as far as you're aware?
There was 2 tenants, and they were girls, and I see 3 males on this list, so I'm not quite sure where, you know.
Okay.
I don't know where you got those names, numbers, but.
The second page is a notice of the summary trial for December 7th, 2010. Correct?
Yes.
Okay. And that's the date that we met in District Justice Lang's office, and you indicated previously that you paid a fine of $1,000, and we resolved this in front of District Justice on that basis at that time.
Yes.
Right? And that was confirmed by a letter from me to you that day. That's page 3 of this exhibit.
Okay.
Okay? Since December 7th, 2010, part of this agreement that was put in front of District Justice Lang was that you were going to provide on an annual basis any new leases which you'd entered into for students living at 54 Garrett.
Correct.
Have you been doing that over the last 2 years?
Absolutely. You have the one from last year.
And what about penalties in your student leases for any additional students living there not named in the lease? Did you change any of your lease documents as a result
No,
of this?
we said it's against the ordinance. In fact, this year we wrote them a letter stating that. We went over there, stating that at the beginning of the year, in October, that they will be evicted from the property if there's more than 2 unrelated.
So October 2011 you did that?
Correct.
Okay. And how often do you personally visit this property to determine whether or not there's any violations occurring?
I'm in the neighborhood, so, I mean, you know, maybe once a month, once every 2 months.
Do you document that at all?
No. Nope.
Anybody document that? You don't do it, your partner doesn't do it?
He probably does it more than I do it.
So somebody might have a record of how many visits and what was found there?
Somebody might.
Have you ever evicted any of your tenants for violating the township ordinances?
Yes. Not in this township.
Well, in this township.
No.
So since 1988, you've owned the property, and have you ever observed any ordinance violations for any of your tenants since 1988 at 54 Garrett?
Not that I'm aware of now.
So you're not aware of any? No trash, no too many people living there?
The too many people. If we get a complaint or something, we try to nip it in the bud. We try to go over there and explain to them and kick them out. See.
Okay. Do you remember prior to 2011? Do you recall receiving any kind of violation notices or any other type of citations from the township for this particular property?
Not that I'm aware of.
But you're the owner of record. You're the person that the township communicates with on this property, correct?
Mostly. Bill has a good rapport with Ben, so my partner, so he does get the calls sometimes.
Okay, I want to ask you about your lease, if you still have that in front of you. In paragraph 22 of the lease, if you could go to paragraph 22, it talks about subletting and assignment. And it states that lessee shall not sublet any part of the premises, nor will they assign this agreement to anyone without first obtaining written permission from lessor. Lessor shall not withhold permission unreasonably. This particular property, you had 2 students on your lease. Are you aware of those 2 students subletting or assigning any of the rooms in this 4-bedroom
No.
twin to anyone else?
No.
How about in the past?
Never.
So you've never given anyone any permission
Absolutely not.
to sublet any part
Nope.
of these?
Sir, if you could, I mean, you're doing fine, but if you could just not talk over each other, let him finish the question. One, because it's just
Sure.
completely impossible for a court reporter to get both of you talking at the same time. But also, it's very difficult for the board to follow. So
Gotcha.
I know we all think it helps move things along, but in reality, in a hearing setting like this, it makes it difficult for the board to make a decision.
Okay.
And for the record.
If you could look at paragraph 21. It's called guests. It says, lessee may house any single guest for a maximum period of 14 days every 6 months, or for whatever the other period of time the law allows, provided that they maintain a separate residence.
Right.
Have you ever gotten any notice from any of your lessees that they're going to have a guest staying there for 2 days, 4 days,
Extended period?
14 days? You ever get any notice from any tenants?
No.
At 54 Garrett?
No.
You also have a covenant, a provision in this lease, paragraph 35, that talks about peace and quiet. And there's an obligation in here for the lessees. It says lessees are entitled to have the quiet enjoyment of their dwelling. Their neighbors are entitled to the same. Lessees agree to refrain from making loud noises, disturbances, and to keep the volume of the music and broadcast programs down at all times so as not to disturb others' peace and quiet. So that's an obligation you're imposing on your tenants to be quiet at this particular address, correct?
Yes.
And not to disturb the neighbors that live close by, correct?
Correct.
Have you ever evicted any of your tenants for violating this covenant?
No.
Do you know if any of your tenants ever violated this peace and quiet covenant?
I'm sure they've had their nights where they've been out of control and the police had to cite them.
And when the police cite your tenants, what do you do about it? When you find out there's been a citation,
Right.
what then do you or your partner do in terms of those tenants?
We try to sit down with them and say, look, this is not, it's not going to be tolerated. We're going to end up, basically evicting you from the property if that continues.
But you've never done that, right?
No.
Since 1988, you've never done that.
Correct.
Paragraph 42 of your lease talks about trash. Lessees agree to dispose of ordinary household trash by placing it into a receptacle for collection. And then in part, it says, the third sentence, lessees are responsible for providing their own trash receptacles and for obtaining or understanding the refuse requirements of the township. Do you know if any of your tenants have ever violated this provision
I
of
don't
your...
know. I don't know.
You don't know?
Don't know.
No one's ever complained to you about excessive trash on the sidewalk, on the porch, in the backyard? You've never had any communication from neighbors or from the township, is that right?
Correct. Other than last week.
What happened last week?
They put out a bulk trash pickup for the night, for the following day, and an officer called me because one of the mattresses was on the sidewalk, blocking the sidewalk.
Were you cited for that?
Yes, they did send me a citation. Yeah. I think
So-
he was... Go on.
Go ahead.
No, I think the officer was unaware that I called him back, that he was unaware there was a bulk pickup the next day, and that apparently some kids were playing with the trash, the mattresses, and that's how they got on the sidewalk.
Okay. Okay, Mr. Liotta, your lease also identifies the amount of rent which you collect for this property. And by my calculation, it looks like $44,000 a year. Does that sound accurate? That's on top of the security deposit of $5,600 on the front page. It looks like it's collected quarterly, am I correct on that?
Yeah, on this property, yes.
Okay. So you collect $44,000 in rent, and you have paid, I think, a $1,000 fine once to Radnor Township, correct?
I guess, yes.
Describe for me again how you keep track of how many people are living at this particular property. Just drive-by inspections, either you or...
That's the best we can do, drive-by inspections.
And you've never observed any evidence that there's more than 2 people in this rental unit?
Not when I drive by.
You drive by when school's in session?
Typical, yeah.
Mr. Leon, I want to show you what I'm going to ask the court reporter to mark as Exhibit T3. Okay, Mr. Liotta, have you had a chance to review that?
Yes.
Okay, this is a formal warning under the township's housing code that was sent to you. Well, it's dated October 11th, 2011, correct?
Correct.
And this is a warning, and it cites to Chapter 226 on the front page, 3 violations of the article, and then it cites to 3 dates: September 13th, 2011. Tenant or guest issued citation for violation of Radnor Township noise ordinance. September 28th, 2011. Tenant also issued citation for violation of township noise ordinance. And there's a reference to an October 11th, 2011 violation notice of the township zoning ordinance, correct?
Mm-hmm.
Okay. And you received this?
I think so.
Did you do anything in response to this?
This was, I think, the letter that we sent to the tenants that they would be evicted if they have one more violation.
Okay. And we already know that you've never evicted anybody, so there was no eviction. You didn't do any eviction as a result of this, correct?
No, no. The third violation. There wasn't really a third violation yet.
Okay. Did you discuss this formal warning with any of the township officials, with Mr. Miller?
Yes, I think it was on the phone with Mr. Miller.
Okay. And you didn't contest this formal warning. You didn't file an appeal or anything, correct?
No, Bill's basically response was, "Hey, what are you guys going to do about this?" And we, Ben and I, put together the letter to certify to the girls that if there's one more violation, they will be evicted from the property.
You think those letters really work with student tenants in these buildings? I mean, do they pay any attention to you? Because it's clear that in this case, wouldn't you agree that there were still problems at this property?
After this, the
Yes.
only problem we heard of was that they had a barbecue, and someone's parking in someone else's driveway, and that's where the third violation became in effect.
Okay.
So, I mean, I'm sure I can answer the question, do you think they do anything? But
I'm going to mark another document that's dated October 11th, 2011 as T4. Mr. Liotta, this is another communication from the township. It's called a zoning enforcement notice. Do you recall receiving this?
I think so.
You think so?
Yeah. I received so many of these this year, a couple of them, so.
All from Radnor or other townships?
No, just from Radnor.
Okay. Did you do anything? Well, let me just, if you would look at this, there's a code section and a violation identified in this zoning enforcement notice, correct?
Right.
Okay. And in the body of this, the third paragraph down, it talks about coming into compliance within 14 days from the date of the notice. And it also states that you have 30 days to appeal this to the Radnor Township Zoning Hearing Board, correct?
Correct.
Okay. You didn't file any kind of an appeal?
No, because we went over them. We took, they assured us that there was no more than 2, and then if anybody was there, they'd be leaving.
They assured you, the students?
Yes.
And you believe
tenants.
that? You
Yeah.
believe that?
Oh, absolutely. Why wouldn't I believe it?
You've been in this business since 1988, and you believe that representation without more?
I have to believe, I can't, sit there and call everyone a liar.
Okay. Just wanted to make sure you really believed them. With respect to this property, 54 Garrett, one part of the appeal that you filed states that you have a signed lease for this property for the next year. Is that correct?
That is correct.
And I assume that signed lease is with 2 students?
Correct.
Are they here tonight by any chance?
No. In fact, we told them what was going on and basically gave them back their money. So they don't have it rented at all.
So the lease it's been voided then?
Yeah.
Okay.
Pending this outcome.
Pending what happens here?
Correct.
Okay. What kinds of information do you provide to your renters? My understanding is you've only had students in this particular address for
Correct.
the past 15, 20 years.
Correct.
Right? It's just students.
Mm-hmm.
You haven't had families. You haven't had non-students. It's all students.
Correct.
Okay. So what kind of information do you give the students when they sign the lease about the township's ordinances?
Well, typically we give them all the information that, it's only 2 related. Most of the students all know what houses are student approved. They know the ordinances. But we go over with them, and again, the trash, courteous to your neighbors, all that stuff.
Mm-hmm. But anything in writing? You have any written policy?
No, other than the lease they sign, which has a lot of stuff in there.
Well, according to your testimony earlier, some of it's outdated or it doesn't apply. I mean, the lease that these 2 individuals sign
Right.
has a representation that they're not students, when in fact they are.
Right.
Right? So,
Yeah.
so there's nothing else other than this lease that they get and the
Correct.
rules and regulations that are in that lease.
Correct.
Okay. I don't have any other questions for Mr. Liotta.
Flail.
Liotta, do you have all the exhibits in front of you so far?
I think so.
All right, let's start with Exhibit T1, which is the lease. Have that there?
Yes.
Lease is dated September 29, 2011, correct?
Actually, 2010.
2010. So they were in there for 2 years?
No, it's just that's when they signed the lease.
Okay. Now, when you were in court with Mr. Rice looking at T2 over the occupancy of 3 or 4 persons other than the tenant that you had, one of which was Kara Fitzpatrick.
Right.
Were they that was not the same tenant as was in there in under the lease that's been marked T1, correct?
Correct.
Neither one of the tenants were the same tenants, correct? Now, before you got to court on T2, did you receive a notice from the township about the fact that there were, according to the township, more than the two people you rented to in the property?
I don't recall.
All right. Were you aware?
No, I was not aware.
Well, let me finish the question. Were you aware that there were more than 4 people purportedly living in the property at that time?
No.
So whenever you had the contact from the township, whether it be by notice or the issuance of the citation that led to the hearing at Magisterial District Judge Lang's court, you weren't aware that there were more than 2 people living on the property?
No, I was not.
All right. And you leased the property to 2 people, correct?
That's correct.
And you are aware that the township ordinances only permit 2 unrelated people to occupy rented property?
Yes.
All right. So did you ever give any kind of permission to these tenants or any other tenants to move in more than the 2 people you rented to?
Absolutely not.
Right. The lease doesn't give them that right either, does it?
Nope.
Did they ever ask you if they could move in more than 2 people?
Nope.
After your appearance over the incident in 2010 and your payment of the $1,000 fine, what did you do to make sure that there weren't any further problems with too many tenants in the property under that particular lease?
Again, another visit at the house, just to, basically assure them that they can't have more than 2. If there's more than 2, they have to be out of the house, and that you're going to get cited.
All right.
Or evicted.
And as far as the tenancy of Kara Fitzpatrick is concerned and her co-tenant, were there ever any other further complaints from the township about there being any more than 2 people in there?
Not after that incident. That was early October, and after that, I didn't hear from the township the whole year.
All right. So there were no further problems under the lease under which Kara Fitzpatrick and her co-tenant occupied the premises.
Correct.
Correct. So at that point, you told the tenants that they couldn't have more than the 2 people in there, and that's what they did. They complied. So you took them at their word, correct?
Yes.
And lo and behold?
I'm going to object. Mr. Flail seems to be testifying, and this gentleman seems to be just agreeing with the testimony by Mr. Flail. So I understand this is an administrative hearing and rules of evidence don't apply, but we can have Mr. Flail get sworn in, and then he can testify what he thinks happened.
I understand the objection. Mr. Flair, you might be getting a little too far afield. I understand most of the beginning of it was preliminary information, but we're now getting into some factual issues, so if you could
I'll ask the
not
question.
lead with it.
I'll withdraw the question and ask it another way. After or during the time of this prosecution under T2, did you have any contact with the tenants who were in the property at the time, Ms. Fitzpatrick and whoever else was your actual tenant?
Like I stated before, after the violation, yes, but...
And what did you say to them?
No, they have to understand the student role. They're not allowed to have more than 2 unrelated in the unit.
And what did they say?
And if there is, they assure me there's not. They have a lot of visitors, a lot of friends that stay there. And I said, you can't have that. And they said they were going to take care of it.
And after that, did you make any further efforts to determine whether or not
No, I did not.
they complied?
No.
Were there any other problems, any complaints from neighbors or the township or the police department about there being more than the 2 tenants occupying the premises?
Not the remainder of that year, no.
And at the time of this citation, were these other individuals, to your knowledge, Robert Fitch, Stephen F. Jeffers, and Paul I can't, Shafrizio, it looks like, actually living at the property?
Not that I'm aware of. We've only had female tenants. So.
I mean, at the time that the citation was issued.
Right.
Were there actually 5 people living there?
No, not that I'm aware of, no.
So, well, then why did you agree to pay a $1,000 fine?
That's a good question. Basically, we didn't even really, they had the names listed on here. No one showed up at court. Mr. Rice was complaining about the trash, this and that. They said $1,000 fine. I'd agree to it, and that was the end of it.
Well, that doesn't actually answer the question as to why you agreed to do that.
I couldn't tell you.
Okay. All right, now let's take a look at T3 and T4. They are both dated if you, well, what date is on each one of those documents?
October 11th, 2011.
Now, at the time you received these notices, what, if anything, did you do with respect to the tenants who were occupying the property under what's been marked T1?
Nothing. This is when my partner and I sent the notice to them that they had 2 violations, and a 3rd violation they were going to get evicted.
All right. And did you send them a notice in writing?
Yes. And we copied Bill Miller.
To show you what I'm marking A1, and ask you
Thank you. Excuse me?
Was that letters?
Yes.
The letter you referred to?
Yes.
Was that prepared under your prepared under your direction and control?
Yes, myself and my partner.
And did you have any other contact with the tenants as a result of or at the time of that letter regarding the violations?
No, I think my partner did, but I didn't have it other than this letter.
After that, and prior to the incident on March 15, 2012, were there any other notifications from anyone about any repeat of the violations set forth in either T3 or T4?
No.
All right. And at March 15th, when you received those notices, you've already testified you didn't take any action against the tenants. Is there a reason why you didn't do that?
No.
What time was, when was the end of the lease?
May 20, I think it's May 25th we have on there.
And did you know at the time when they were actually going to be leaving?
Typically the students leave, first, second week in May.
All right. Does that have anything to do with why you didn't take any formal action?
Yeah, the proceedings and everything else. I mean, March 15th, April 15th, it was, such a short span there. By the time we even got an injunction to get them evicted.
And other than what's set forth in T3 and T4, were you ever cited for any other alleged violations of any Radnor Township ordinance, including the residential housing ordinance?
No.
Now, at the time of the the October 11 notices, did you verify or find out who was living in the property, or if anyone was living at the property beside the two tenants?
No.
Were you ever provided with the identity of the people who were supposedly living in the property that were not your tenants by anyone else, such as Mr. Miller or any other township official?
No.
Do you know, as we sit here today, whether in fact there were other people living in the property?
No, I don't.
And do any of your records indicate the identity of these supposed people who were not tenants who were living in the property?
No.
And as far as March 15th is concerned, do you know who was allegedly living in the property at that time that were not your tenants?
No, I don't.
Do you know if there was anyone living in the property who were not your tenants at that time?
I don't know.
And do you have any indication of any kind whether or not it was the same people in March that were there in October, or whether there were different people there, if there were anybody there at all?
I don't know.
Did you have any verbal contact with the tenants regarding either the October 11 or March 15 incidents?
No. My partner might have, but I did not.
And as to the items listed in, I believe it's T3, which has to do with matters other than the occupancy by more than two unrelated persons, were there ever any complaints about a continuation of any of those violations?
Not that I'm aware of.
Even in the March 15th letter?
No, the March 15th, I think that was the last violation. That was the noise violation,
All
apparently.
right. And that was for, do you know what that violation was for?
I don't know the details. Apparently there was a noise violation from a party or something.
On March 15th?
Yes.
Or
I
about-
think so, yeah.
Okay. And as we speak, is there anyone occupying the premises now?
No, there's not.
That's all I have on this witness at the moment.
Mr. Fennell, any recross?
Just a couple of short questions.
Mr. Rice.
Mr. Leota, Mr. Flail asked you a question, and the question was, other than T3 or T4, which are the October 11th ordinance notices, he asked you whether you've ever been cited for any other Radnor Township ordinances, and you said no.
Oh, I thought between October and March. That's my mistake. Is that what you're...
Was my question.
Yeah, that's what I thought.
Then I, okay.
Yeah,
I
Mr. Rice,
misheard.
that's my understanding.
Okay, I misheard that. And we talked about December 2010 and that hearing and the $1,000 fine. Prior to that, were you ever cited for any other township ordinance violations?
I might have been. I just don't recall. I can't say I haven't.
But the citations would have come to you, right? Yeah, I mean, we have
Well,
your
that's
name and your
sometimes the
P.O.
contact,
box
yes.
number as the property owner on
Correct.
this, correct?
Correct.
Okay. And Mr. Flail also asked you what you knew about anyone that's not on your lease living there and you don't seem to know anything.
Mm-hmm.
about anybody that might have lived there in the fall of 2011, anybody that might have lived there in March of 2012 when there were some
Right.
issues. So you don't know anything about anybody else living there,
Correct.
right? Okay. And you don't know anything about back in 2010 when you paid a $1,000 fine.
Right.
You don't know anything about any of those people that were listed on the citation notice who also got citations, correct?
I'm not actually. I don't know. That's a good
Okay.
question.
You don't know that they were also cited at that time.
No, I don't.
Okay.
I didn't know that.
But you don't know anything about that either, about any of those other people other than your tenants
You have
on
to
the lease.
understand, I do have a partner. He manages it more than I do. Okay? So
So he might know about
he might know.
more than 2 student tenants. Okay. So this is what I would describe as the ignorance is bliss defense to this, correct? If you don't know any,
To that.
I'm not.
And do I have to state a grounds?
Mr. Rice, I'll sustain that objection. It's more than just a little argument.
okay, I just came to mind. It's an old saying. I don't have any other questions for Mr. Liotto.
No more at this point. I may present him again as part of our defense.
Absolutely. You have the right to recall him, Mr. Flail. Sir, thank you. You can step down.
Thank you.
Mr. Rice, whenever you're ready, your next witness.
I'd like to call Kevin Gallagher.
And sir, if you'll raise your right hand, I'll swear you in. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And state your full name for the record, please.
Kevin Gallagher.
Thank you.
Okay. Officer Gallagher, what is your position with the Radnor Township Police Department?
A corporal with the police department.
And how long with the department?
I'll be starting my 20th year in September.
And how long as a corporal?
Since 1998, so 13, 14 years.
Okay. You've heard the discussion about 54 Garrett Avenue. Are you familiar with 54 Garrett Avenue?
I am.
Okay. Have you, I asked you to look for any incident reports over the past year or so regarding 54 Garrett Avenue. Did you find any?
I have, yes.
Okay. How many do you have there, Officer Gallagher?
5 years. One on, excuse me.
Okay, Mr. Economides, what I'd like to do is I can mark them as a group or mark them individually.
Mr. Rice, I mean, it's no preference on our point. Whatever you think is going to help with your case, it's your
Okay.
case.
I'm going to mark them individually, I think.
You have the T5.
Okay.
You have the number.
That sounds right.
Mr. Flail, this would be T5, I believe. I'm trying to keep track of as well. I think. Yeah.
I believe that would be T6, actually.
Yeah, I think that's 42.
Is it 5?
Yeah, you're up to T4 on this
Yep.
end.
Okay.
Just making sure as well, but I want to
Okay.
make sure we're on the same page.
I have an objection to this in the first place. This involves an alleged incident on May 12th. After this appeal was filed, there's no they don't even name the person, just that it occurred allegedly occurred at 54 Garrett Avenue. And how is my client supposed to know about this if he's not involved?
Well, before you read the entire exhibit into the record, I understand your objection, and it's a valid one. I mean, it's the first time I'm seeing it, and if the board hasn't even seen it yet. So when I give Mr. Rice an opportunity to respond.
Well, I think the relevance of this is, again, the testimony that we've just heard from Mr. Liotta, that he had no complaints after 2010, and there's been no other problems on this particular property other than what's happened in October 2011 and then March 2012. So the appeal grounds state that, again, that this landlord has been a model citizen and there's never any issues there, and Mr. Liotta knows nothing about anything that goes on there. So these are all public documents or incident reports that establishes a pattern for this particular landowner and a troublesome pattern for the residents in that neighborhood. So I think it has some relevance in terms of all of those issues, and in terms of rebutting what seems to be part of the defense here is that there's no problems out there.
If I may, I believe that's the 2011 date, as long as we're on the same page.
Yes.
Correct.
Okay.
Yeah, May 12, 2011.
Okay.
Correct,
Yeah.
Mr. Flail. That's your objection.
I missed the date.
Yeah, T5 is a incident report dated May 12th,
His testimony.
2011.
I'm sorry. I thought he was finished. His testimony, Mr. Liotta's testimony, was that he wasn't aware of any. There's no showing here that he had any knowledge of this. And, of course, this is done with the purpose of inflaming the panel's decision-making process here to get down on the applicants, the appellants, for violations of which they aren't even aware. And this witness is not competent to testify because he wasn't involved. He wasn't even the officer involved.
Mr. Flail, I would have to, Mr. Rice, I have to agree with Mr. Flail to the extent that if you're using this to impeach this witness, unless you can make a offer of proof that he was provided this notice, I don't know how we can now try jumping back. You'll have another chance with Mr. Liotta if and when he's called on direct to try to attack his credibility as to that issue with this document, I would think. But I have to agree with Mr. Flail that this being issued after the fact and your stated reason that you're using this to impeach his credibility, from the document itself, I agree with Mr. Flail. I can't tell whether or not he knew about this or not. But you may be able to establish that if you're going to make an offer of proof as to that.
It's not just a credibility issue. That's not the reason. If you look at this particular incident report, and the questions that Mr. Liotta was asked by Mr. Flail asked conclusory questions. Were there any problems there? No. Some of them said, were you aware of any problems? He said he wasn't aware of them. But the questions that he asked him were you aware of any other reports? Were there any problems at all? And he doesn't know anything about anything that happened here. He was also asked about the tenants that were cited in 2010, one of whom was Kara Fitzpatrick. He stated that there weren't any problems with these tenants after 2010. Yet we have this police report with Kara Fitzpatrick's name on it as the person involved. The one person he identified as a tenant that had a lease. So it's not a, and I respect whatever the board's decision is on it. I'm going to offer it anyway, and if the board doesn't accept it, so be it. But I think this goes more to Mr. Liotta's credibility. It goes to a problem in the community. It goes to a pattern. And I think this panel has the ability to consider the testimony of Mr. Liotta against what I think is a lot of is overwhelming evidence of a ongoing problem at this address.
Unless he can link this incident to Mr. Liotta's knowledge, it doesn't impeach his testimony, and it's totally inapposite to the case. It resulted in no citations against the owners for any violations of the rental housing ordinance. My clients are not the parents of these people. They are adults, They live in these premises as any other tenant does. It is a violation of my client's rights. It's a delegation of the administrative duties and powers of the township and the police department to try to imply that my client has to go around and play cops and robbers with these tenants to find out whether or not they've been cited with any violations. He testified from his knowledge. Unless there can be a link made that Mr. Liotta was aware of this incident, it's totally irrelevant to this proceeding, and it shouldn't be admitted because it's prejudicial.
Can I just I'll be short.
Well, we could go back and forth, I think, with this all night. I mean, let me raise one point. I understand the objection. I think the distinction that Mr. Rice was able to state in response to your objection essentially is that it's not whether or not he had notice of this, but the fact that you've raised in your argument and your direct testimony of him is that he wasn't aware of these. And I think the point being made is that that's the point that's trying to be made with this piece of evidence now, is that yet another piece, perhaps. I don't know if that's what he's going to try to establish.
But there's no
But
link.
I think that distinguishes it. Well, and I think that's his point exactly. Whether or not he had notice of this, he didn't know what's going on at his property. And I'd like to hear your response as to whether or not assuming you're correct, that we can't link this piece of evidence to him knowing about it. Putting that aside, do you think there's relevance to the fact that he doesn't know that there's citations being issued to his tenants?
No,
I think
I don't-
that's what we're looking at here with this piece of evidence.
I don't think he has
and
to
Mr. Rice,
be-
please correct me if I'm wrong.
Well, let me
let Mr. Rice please respond to that, because I think this is
there's a
important.
further issue, that he doesn't know what's going on at these properties. He sends letters, and he must know they're not going to confess to having 3 or 4 other students there, but he sends letters. But the other thing that has been raised in this appeal is what the code officer did. And what is alleged here is that the code officer did not consider any of the elements of the ordinance. And if you look at the ordinance 226-8, before discipline gets imposed, before suspension gets imposed, the code officer shall consider the following criteria: the effect of the violations on the health, safety, and welfare of the tenant and other persons within the premises, the impact of the violations on the neighborhood, whether the owner has committed prior violations of this ordinance or has received prior notices, whether the owner has been subject to disciplinary proceedings, action taken by the owner to correct violations, the policies and the lease. So there's a whole series of things here that he's attacked, basically saying in the appeal that Mr. Miller didn't consider anything in here, when in fact there's a long history here of documented violations, whether he knows about them or not, documented incident reports, whether he knows about them or not, that Mr. Miller has the right to rely on in issuing his March 27th suspension. So, I mean, I'm putting this in for all of those reasons. It has nothing to do with trying to, his knowledge of these incident reports or not, I don't think matters in terms of what I'm attempting to do with putting these records in.
He's switching horses. Since one argument didn't work, he's now trying to get to Mr. Miller's case, which he hasn't even presented yet. The fact of the matter is, my client can't be cited for violations, nor can he be prejudiced by the consideration of violations that he didn't know anything about. So if they can't show that he didn't know anything about these, they're totally irrelevant and they're prejudicial. And no, my clients do not have to play cops and robbers and go find out exactly what's happening there 24/7 in order to comply with the law. That's what the township may want to have happen, but that's not relevant to this proceeding.
And I, with all due respect, I think that goes beyond the objection that we're looking at here. That may be your ultimate argument, maybe trying to convince this board of that, and that's going to have to be their decision as to whether or not you're correct on that. But as to this piece of evidence, I think that it is relevant based on frankly, what you raised with him on direct as to what he did know or didn't know. And I think it's further evidence of, as what Mr. Rice it may or may not establish with this piece of evidence, but his proffer is that's where he's going with this, to establish that your client doesn't know what's happening at the property. So without saying any more, I would recommend that the board allow this piece of evidence in and then we continue with the hearing at this point. Your objection is noted for the record. I'm assuming it's a continuing objection.
It is.
Okay.
Mr. Rice, and this will be T5.
T5, and I would just like Officer Gallagher to identify this incident report.
This incident is numbered 1100049994. It was reported on the 12th of May, 2011 at 20:36 hours, 8:36 p.m.
And who's the person involved in this incident?
The name is Kara Fitzpatrick, with shows an address of 54 Garrett Avenue.
And this is a document that's kept in the normal course of the police department when there's a complaint and there's a response by the department.
This is a police incident. This is the police incident report.
What was the disposition of this incident? Can you tell?
Yeah, exactly. What the officers found, it was Officer Myers was the officer assisted by Sergeant Pinto. When he responded and spoke to Kara Fitzpatrick, who reported there was a small group gathering of Villanova students that were graduating on the 13th, and she just advised that the residents would be leaving, or excuse me, the guests would be leaving the residence.
Yeah, I'm going to object here again. Corporal Gallagher was not involved in this incident.
Actually, I was in this one. I'm not listed. I was just an additional officer.
All right,
There's
well,
4 of us, sir.
Before this gets out
The
of hand.
document speaks for itself.
Go ahead and finish your objection.
The document speaks for itself. We don't need his characterization of it. It speaks for itself. If you're going to let it in, you can see what it says.
If it was hearsay, we may have gone a little further with this objection, but if he has personal knowledge as to this, he can testify about it. So I'll overrule the objection at this time.
Okay, Officer Gallagher, got another incident report, which is being marked as Exhibit T6.
Thank you.
Do you have that in front of you?
I do, sir.
Okay. What's the date on this incident report?
September 13th, 2011.
And who's the person involved in this incident report?
Julia Lynch.
Is this again were you personally involved in this?
No, sir, I was not.
Okay. And what was the disposition of this particular report?
I'll read just directly from the report itself.
Objection again.
I'm
The
fine.
document speaks for itself.
Okay. It does say that there was a citation, a summons issued, though, correct?
Correct. It was issued for a violation of the Township noise ordinance. The person on the citation was Julia Lynch.
Officer Gallagher marking another incident report as T7. Can you identify this briefly?
Yes. Again, police incident report number 1100100235. The report date was September 28th, 2011. It was a Wednesday at 01:28 a.m.
The person involved?
Was a Marine Mutual, I'm going to say M-U-C-H-E-L.
And this was a complaint about a large, loud party outside of your residence.
Correct.
And this is 54 Garrett, correct?
Yes, it is, sir.
incident report that's been marked as T8. Could you identify that?
Yes, sir. Police incident report number 120003169. The report date is March 14th, 2012 at 19:10 hours, which would be 7:10 p.m. Wednesday for 54, excuse me. The initial report came in as 58 Garrett. When the officers arrived, they determined it to be at 54 Garrett Avenue.
And who's the person involved in this particular?
Marissa L. Brown.
Can you tell from this whether there was any citation issued?
There was no citation issued for this one.
One final incident report. Marked as T9. Okay, do you have T9 in front of you?
I do, sir.
And could you describe what T9 represents?
Yes, it's, again, police incident report number 120006145 from May 22nd, 2012, 1924 hours, 7:24 p.m.
Objection. This is clearly beyond the time the appeal was filed. How is this possibly relevant to any of the issues before this panel this evening?
The same argument. Look, it's the same argument. Like, again, what was raised on your direct of him was that whether or not he's aware of what's going on at the property.
And nothing has been shown to say that he was aware.
Understand. And the township's making a case of that's relevant, and frankly, I think a part of their case that they're trying to make.
So
I
something
think,
after the appeal's filed then comes in on the same basis that things that occurred prior to.
which, and you're raised, I mean, again, you raised his knowledge as an issue in your appeal as well as on direct. So I think it's fair game, and I think because of that it's relevant, and frankly, even without that, I think it's relevant. But
there's
absolutely in this proceeding, it's been raised. So I think he has the ability to respond to it.
It was raised that he didn't know. Mr. Liotta said he didn't know. There's nothing in any of these documents to show that he did know. And particularly with one that happened after the appeal was filed, how can you attack anything, including and especially his credibility, based on something that hadn't happened when the appeal was filed?
Well, no, I think the township's been clear, their solicitor's been clear that this isn't limited to his credibility alone, that this is a part of their case in chief as to the fact that he isn't aware of what's going on and that all of these violations exist, but he still isn't aware of them.
How do you...
The board can weigh that as, any way they want, but for purposes of getting in, I think it is relevant. So it's the same argument. I understand it. Your objection is noted for the record. It's a continuing objection. Mr. Rice, whenever you're ready.
Okay. Officer Gallagher, T9.
Yes, sir.
If you could explain what T9 represents.
It was a complaint at 54 Garrett Avenue for a large amount of trash at that residence.
Okay. And what was who was the person involved in this?
They spoke to the, there's two people named, both John Liotta, I believe, if I'm pronouncing that correct, and also the Marine Mutual.
Okay. It says Frank Mutual.
Yes,
on the second
that's,
page.
if you look at it as a typo, and if you compare that with item T7, or evidence T7, with Marine Mutual, that is the same information, date of birth, New Jersey driver's license. That is a typo. It should be Marine Mutual for T9.
And there were citations issued to
That is correct. There were
both
two
Mr.
citations,
Liotta
one
and
to
Mr.
each
Okay.
individual.
I have no other questions for Officer Gallagher.
Mr. Flail.
Starting with T5, you were directly involved with T5, correct?
I was present, yes, sir.
And did you or to your knowledge, did anyone from the police department ever advise Mr. Liotta or any other person connected with this property that this incident had occurred?
To my knowledge, just the residents that we spoke to there.
And with respect to T6, are you aware whether or not that incident was ever made known to Mr. Liotta or anyone connected with the any other owner of the property?
To my knowledge, not any other owner, no.
And T7, oh, by the way, back on T5 and T6, Mr. Liotta was not cited in either one of those incident reports, was he?
No.
T7, was Mr. Liotta cited as a result of that incident report?
No, not according to the incident, no.
Was there anything, to your knowledge, to indicate that he was made known that this incident ever occurred?
I cannot answer that, and my answer would be just be that we notify, the police department notifies the codes department.
And with respect to T8, does Mr. Liotta or any other representative of him or executive property management cited as a result of this incident report?
Not on our incident, no.
Was it otherwise made known to him or anyone at executive property management, to your knowledge?
Not to my knowledge.
Now, with respect to T9, Mr. Liotta was cited in this particular instance, was he not?
Correct.
And were you involved in it directly?
I was not.
So you don't know whether or not there was a permit issued for the collection of the trash that was used as a basis for this citation, correct?
I do not know. Correct.
And do you know what officer was involved with that particular incident?
Officer Bates and Sergeant Campbell.
Is Officer Bates here tonight?
I do not believe so, no.
All right. And with respect to any of these other incident reports, T5 through 8, are the officers involved here tonight?
I believe Officer Coco is on duty tonight.
He's on duty, but he's not here.
It's a female, correct.
So basically what you did is what you were asked to do, which is just to dig up records.
Correct.
And other than the one you were directly involved with, you don't really know any of the particulars that occurred after that, except the fact that Mr. Liotta and Executive Property Management were not charged in any but the one you mentioned.
Just what's in these incident reports, correct.
That's all I have.
No other questions.
Thank you.
Superintendent Colarulo.
Sir, if you'll raise your right hand. You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And will you state your name, please?
William Colarulo, C-O-L-A-R-U-L-O.
Superintendent Colarulo, you're the police chief for Radnor Township, is that correct? It's tough getting used to this. You are the police superintendent of Radnor Township currently, correct?
Yes, sir.
And how long have you been in that position?
I've been in this position for 15 months.
Okay. You've sat through the hearing tonight. You've heard about 54 Garrett Avenue. And are you familiar with 54 Garrett Avenue and that surrounding neighborhood?
Yes, I am.
What's the neighborhood like?
The neighborhood is, I would say, densely populated, twin homes, diverse community, various ethnicities, races, ages, does have student housing. Fairly, like I said, densely populated.
Okay, so the houses are relatively close together.
Yes, very close together. Row homes similar to what you would see in Philadelphia, except for the fact that they're twins, but there are also row homes as well.
So if I'm having a party on my front porch at 52 Garrett Avenue or 50 Garrett Avenue, there's going to be a fair number of residents that are going to hear, if I have music and it's loud, they're going to be able to hear that noise, correct?
Absolutely.
Okay. We've marked already tonight some incident reports that dated and some notices that dated from last fall. Exhibits T3 and T4 were notices of violation that were issued by Mr. Miller. Did this property or any problems come to your attention in the fall of 2011?
Yes, Counselor. In fact, this property came to my attention even before that on a number of occasions.
Could you just describe what your personal contact was with this particular property?
Sure. When I first got here, relatively quickly after my arrival, I was informed by a number of the residents, some that are here tonight, about the ongoing problems with the student rentals, and in particular, 54 Garrett Avenue was definitely one of the biggest violators for a number of years. In addition to that, I went to a meeting at, I believe it's called the Bryn Rose Association, and
Object to this testimony. It's all hearsay.
Mr. Rice, I have to agree with that. I mean, if we can get to some personal knowledge as to what he knows about as opposed to what he's been told by someone else or at other gatherings and so forth.
Okay.
We'll sustain the objection.
We can get to that, but well, I'm not going to comment on the hearsay objection. But Superintendent Colarulo, have you had any contact with Mr. Leota since you've been in the position that you're in?
yes, I have.
Okay. Could you describe, what your contact is with Mr. Leota in this particular property, and any observations that you've had regarding this property back in the fall of 2011?
Yes, in the month of September 2011, I began to receive a number of complaints from the residents, a number of which were afraid to come forward and give their names.
Action, same basis.
He could tell us that he's received complaints.
Sure.
But he didn't object till he started saying what was the content.
Right. So if we can limit it, if he's received complaints, he could tell us about that. He can tell us what he's ultimately done as a result of those complaints. But I would have to agree that if he starts telling us what he was told specifically without him having personal knowledge of it, it's hearsay. Now, I understand it's an administrative hearing, but
Right.
and the rules are much looser. But
Okay. So as a result of the complaints, well, let me ask you this. Did you receive complaints from neighbors about this property?
Numerous.
Okay. As a result of that, as a result of those complaints, did you contact Mr. Leota?
Yes, but also if I could just elaborate, I did drive through the neighborhood and did witness a number of students on the porch that immediately ran away when they saw me. Right after that, and based on the incident reports that Corporal Gallagher talked about a few minutes ago, I called Mr. Leota in my office for a meeting.
And who was at that meeting?
Myself, Corporal Gallagher, and I believe Mr. Ray Daly, D-A-L-Y, and Mr. William Miller, M-I-L-L-E-R, which are responsible for code enforcement.
And what occurred? Did Mr. Leota come by himself?
Yes, he did, and I memorialized a summary of that meeting of what occurred, and I have it here.
Okay, well, let's mark that as T10. Superintendent Colarulo, you're looking at an email that's...
I'm sorry. Yes, I do.
An email that's been marked as Exhibit T10. Mike. It's been a while to get used to this, but what's been marked as T10 is an email that has a date of October 7th, 2011, correct?
That is correct.
And this is the day after the meeting
Yes, sir.
you had with Mr. Leota. Could you just briefly describe, I don't think you need to read the whole email, but just describe what the contents of the email and the result of that meeting?
Okay. This meeting basically, what this email states, the meeting was to put Mr. Leota on notice that we have a zero tolerance policy, that any further infractions will not be tolerated, that he will be held strictly accountable for the conduct of his students. He expressed during this meeting that his students felt unjustly harassed by some of the neighbors, and he claims that the neighbors yell at the students. And he was put on notice, as I stated. I explained to him that we would not tolerate this, and he would be held strictly accountable for any infractions, that he was responsible for that rental, and he was responsible for the tenants, and that he would face inspections and further infractions if the conduct continued by the students.
Okay, now, in this email, at the end of the second paragraph, the large paragraph, you state, I told Mr. Leota that this letter was given to the residents at 54 Garrett on 3 separate occasions to ensure compliance. What letter is that?
Yes, Counselor, on the table, there's a green piece of paper and a pink piece of paper. At the beginning of the school year and at the end of the school year, my officers give copies of that letter to all students renting properties in Radnor Township to let them know that we have a zero tolerance policy and what type of conduct is accepted and what will not be tolerated. Mr. Leota was also given copies of that letter at the meeting that took place in my office.
Do you know whether Mr. Leota distributed this letter to any of the tenants himself?
I'm not sure, but we did that distribution to 54 Garrett Avenue 3 times to make sure that there was no doubt that they received that letter.
I guess I should mark these letters as exhibits T11 and T12. Green letter will be 11. Pink letter will be 12. Okay, Superintendent Colarulo, the green letter is August 2011. That's the beginning of the school year. Is that correct?
Yes, sir.
Okay. And that's been marked as T11. And the other letter is dated April 2012, and that's been marked as T12. So you, on 3 occasions, you had a reason to go to 54 Garrett, and do you remember which students you gave this to, or your officers gave this to?
It would be the students that were there at the time I visited in March and went to that location.
Okay, same students.
Yes.
Okay. Well, let's talk about March. We've had an incident report marked on an incident of March 14th, 2012. You're familiar with that incident?
Yes, sir.
Okay. As a result of that incident, did you take any action regarding 54 Garrett?
Yes, it was a result of that incident and as a result of 3 separate emails from 3 concerned neighbors about the conditions at 54 Garrett Avenue.
Okay. And what did you do as a result of those emails and the conditions out there?
At 9:30 a.m. on Thursday, March 15th, I'm sorry, yes, on March 15th, which was the day after, I personally drove to 54 Garrett Avenue. It's, again, at 9:30 a.m., and I went and visited the premises and spoke to the tenants.
Okay, did you memorialize that conversation, or?
I memorialized the conversation to my immediate supervisor, who would be the township manager, Robert Zinkowski, Zinkowski.
I'm going to ask to have an email dated March 15th, 2012 to be marked as Exhibit T13. Okay, Superintendent Colarulo, could you, this is the email that you sent to the Township Manager and the Code Department on the day after you visited the site, is that correct? Or the day of visiting the site?
Yes, sir.
Okay, could you just summarize what you observed there and what the conditions were at your visit?
With your permission, I would like to read this in its entirety.
Objected it because it includes statements that were allegedly made by Ms. Brown. I haven't had a chance to read it, and possibly other people who were there, which are once again hearsay.
Why are they hearsay?
Well, yeah, I was going to say, this is his summary, his recollection as to what was discussed, or what was the outcome of that discussion.
It says that Ms. Brown made the following admissions.
That doesn't make it hearsay.
It does, because in order to admit something, you have to make a statement. And if the person who made the statement isn't here and is not a party, it's hearsay.
Only if it's offered for a certain reason. You know, this is an investigation that the police superintendent did, and this is his report of what he found. This is a document that's kept in the normal course of documenting these types of activities. They're done by email. They're done on formal reports. This is not hearsay. Everything that it's said out of the meeting room is not hearsay in this state.
Assuming what it's offered for, and if it's not being offered for the truth of the matter asserted. So whether or not the statement's true or not, the board, that'll be left up for another time. But I agree. This is it's no different than the incident report, frankly. It's the same reason those get in. So I'm going to overrule the objection, note the objection. I'm sure it's a continuing objection. Mr. Rice, if you can continue.
Superintendent Colarulo, if you would, I know you want to read the whole email.
I don't know that it's necessary. I mean, it's...
Well, let me do this. You referenced 3 emails from residents that you received that live on Garrett Avenue: Robert Adams, Lynn Ellis, and Sarah Pilling. Were they? What was the emails and what were the reports that you received from those residents?
They were concerned about the incident that happened the day before.
On the 14th of March.
That is correct.
Okay. And we have an incident report that documents some of the activities from that day, correct?
There were 2 separate incident reports. That's correct.
Okay. So you, in the 3rd paragraph, you state, based on my review of the attached incident reports and the emails, you personally visited 9:30 a.m. with Corporal Kevin Gallagher. Is that correct?
Yes, sir.
Okay. So then upon arrival, what were the physical conditions that you observed at this property?
I can read this.
Yes.
It says, upon my arrival, I observed a large black trash bag on the porch, which was untied, and it contained trash and remnants of alcoholic beverages. I knocked on the front door, and I heard talking and a dog barking inside the residence. Within seconds, a white female in her early 20s, who was later identified as Marissa L. Brown, who was lessee number 1 on the rental agreement, opened the door. I identified myself and asked permission to come in and speak with her and the other residents. She allowed us in, and upon entering the residence, I observed another white female sitting on the couch wearing a gray Villanova lacrosse sweatshirt working on a laptop computer. She was later identified as Maureen G. Muchel, M-U-C-H-E-L, lessee number 2 on the rental agreement. I also observed a white male in his early 20s who quickly ran up the steps. He was later identified as Alexander Dempsey Olsen, O-L-S-E-N, the boyfriend of Miss Muchel.
Okay, so that you walked in, there were 3 people that you observed immediately in the house, correct?
That I observed immediately, yes.
Okay, and then your next paragraph describes the condition of the living room. If you could just read that paragraph.
I would describe the condition of the living room as extremely messy, excuse me, with the following items discarded on the floor or on the coffee table: a frying pan filled with grease and burnt bacon, cigarette butts, dirty paper plates, and cigarette butts and other miscellaneous trash and garbage strewn about, which would be indicative of the aftermath of a party. I explained to the 2 women that I was there as a follow-up to the loud noise complaints I became aware of. I asked for identification for all present, and I asked for a copy of the lease to review.
Okay, so as you entered, you observed that, and then you spoke with your report, and your report indicates that you had a conversation with Ms. Brown. And what did she tell you at that time?
Ms. Brown indicated that 4 people were living at that location despite the lease only having her and Ms. Muchel listed as the lessees. And she also stated, quote, "The landlord is fully aware of 4 people living here."
Let me stop you. Did she tell you how the landlord would be aware of that? Any?
I'm going to object to this. It's not even in the memo. What he's about to say, I don't believe is in the memo. So then it's truly hearsay.
Well, we don't know what he hasn't answered my question yet.
In the course of his investigation, if he becomes aware of something as a result of his investigation, I think he can tell us what the result of that is.
He's quoting what she said. It's hearsay.
I'll withdraw the question. So after Ms. Brown makes that statement about the landlord's knowledge, then could you read the rest of this?
Sure. Ms. Brown admitted that the other 2 full-time residents were Julia Lynch and Catherine, I guess with an E at the end, Savio, S-A-V-I-O. And I also put in here, please note that Miss Savio, who was not on the premises at the time of my visit, gave the following quote to the Philadelphia Inquirer on March 12, 2012, in an article which was titled, "Radnor Residents Feel Like Townies." And her quote was, "We understand we disturb adults and families who live here, but where else can we go?" asked Villanova senior Catherine Sanyo, it was misspelled, 22 of Margate, New Jersey, who shares a 4-bedroom twin with 4 other students. That was her quote in the Inquirer.
So that would be 5 students living there.
That's correct.
Okay. And then the rest of your report, Ms. Brown indicated what else in this report?
When asked, Ms. Brown also admitted that another woman was upstairs sleeping. Excuse me, and I instructed Ms. Brown to wake her up so I could speak to her. And this woman was identified as Julia Lynch, 21, who also admitted to living at this residence full time. In addition to the above, I conducted a visual inspection of the outside of the property and witnessed the following 3 vehicles parked in the driveway of 54 Garrett Avenue. And it was a Nissan with a New Jersey tag of Z as in zebra, Z as in zebra, T as in Tom, 24H as in Harry. There was a Volkswagen with a New York license plate, F as in Frank, C as in Charlie, V as in Victor, 9701, and a BMW with a Pennsylvania tag of H as in Harry, F as in Frank, N as in Nathan, 3716. And this is the same vehicle that received a parking ticket the night before at 10 p.m. for blocking the sidewalk. Another vehicle was parked directly in front of 54 Garrett Avenue. That had a New Jersey plate of V Victor, G George, R Robert, 37J as in John. And I'm sorry, I don't have the model of that car. Yes, sir. It says it is important to note that Marissa Brown, again, lessee number 1, in particular acknowledged to me that she knew she was in violation of the 2-resident rule and was quite concerned that they were going to be, quote, kicked out or, quote, cited. All of the residents also expressed concern that these infractions were going to come back on the landlord as well. I explained that we were there to ensure peace is maintained and that all information will be forwarded to the appropriate department for follow-up.
And as a result of your investigation, your report, the township then issued a citation, or Mr. Miller issued a suspension notice, correct?
Yes, sir.
Okay. No other questions for Superintendent Colarulo?
Mr. Flail.
Thank you. Just dwelling for a minute on your reading of the quotation about what Catherine Savio supposedly told the Inquirer, the part of the bold print that says who shares a 4-bedroom twin with 4 other students is not part of Ms. Savio's quote. It's part of what was put in the article, correct?
Well, that was taken out of the Inquirer article, yes, sir.
But that part of it, Ms. Savio didn't say. That was just in the article.
That would be what the reporter put in the article, sure.
The only part of that is a direct quote from Ms. Savio is the part that says, "We understand we disturb adults and families who live here, but where else can we go?" Question mark. That's the only direct quote from her.
That is correct.
Okay. And dealing with your statement that Ms. Brown said that the landlord is fully aware of 4 people living here, if she made that statement, did she say anything to you, or did you otherwise come into the knowledge of what she based that statement on?
No.
So if she had it in for the landlord, wanted to get the landlord in trouble, she could have just made that up.
Just quite the opposite, sir. She was very concerned about the landlord getting in trouble. And she was very nervous, and she made that known to me, that she was afraid that the landlord was going to get in trouble.
Did you run the tags on any of these vehicles?
I don't believe I did personally, sir.
Okay. So you don't know whether they were there, belonged to the people who were in there or not?
That is correct. However, I do believe a couple of the cars are registered to those women based on the information they provided on the lease.
But you didn't run the tags, and you don't have documentation here tonight to show that?
I don't believe I have it with me here, but I'd be glad to run the tags for you right now.
And other than statements that were made to you by people who were there, what other information do you have that there were more than 2 tenants there at that, or 2 occupants there at that particular time?
Well, sir, I'm not trying to be curt here, but they admitted that they were living there. What else? What other proof would I need?
All right. You didn't have anything to corroborate that, correct?
If they're admitting it, that's good enough for me.
And you don't have any information as to when they started living there?
No.
So it could have been the previous day?
Or 6 months before.
Correct.
Right.
So from the fact that you don't know when they moved in there, you don't really have any knowledge of your own that Mr. Leota was aware of the fact that they were there?
I have a woman who signed the lease that said to me, quote, "The landlord is fully aware of 4 people living here." As far as I'm concerned, that's all I need.
But you don't have any other knowledge of that?
Again, Counselor, with all due respect, what other knowledge would I need?
Objection. He's asked him the same question 3 times.
Now, as a result of your visit, the only action that was taken was Mr. Miller's letter of March 27th. Is that correct?
I can't speak for other departments. We work with them. However, we do what we need to do, and then they do their follow-up. So you would have to address that to these gentlemen.
All right. Well, you testified a while ago that he issued the letter. You turned the information over to him.
Yes, but I believe you asked if I was aware of that they did anything else other than that, and my answer is you would have to ask them.
Did the police department take any action against Mr. Liotta or Executive Property Management as a result of your visit?
At that particular visit, I don't believe so.
And has the police department taken any action against the owners of this property and at any other time that you're aware of?
I would have to check for how far do you want me to go back, and I will check.
So the answer is you don't know as you sit there?
Exactly, yes. Other than the May incident with the trash, we gave a citation.
And are you aware that the tenants had a valid permit for a large trash pickup for the following day?
They did call for bulk pickup the next day, but that does not relieve them of the responsibility to make sure it doesn't block the sidewalk or block traffic flow in any way.
But you cited Mr. Liotta for that, not just the tenants.
That's correct, because if you look at the ordinance, it says that the landlord is responsible for the behavior of his tenants.
Do you know when the trash was placed on the curb?
I believe it was that evening.
Then how is Mr. Liotta supposed to find out in a few hours that there's trash on the curb, other than the fact that he later subsequently received a telephone call?
Well, sir, I believe you're still responsible for your tenants and their behavior and the way they put trash out. I think you're overly responsible. If you're collecting rent from your tenants, you're responsible for their actions.
Even if he did know about it, and there's very little chance that he could have known about it because of the lack of time between the time the act occurred and the time that the violation was seen.
If you're asking my professional opinion, I don't believe ignorance is an excuse in this case.
That's all I have.
Thank you.
I think we all need it, yeah. I mean, Mr. Chairman and board? Yeah.
I have one more witness, Mr. Miller.
Okay. Mr. Flair, how many witnesses do you have or expect? Just to give us an idea.
I'm not sure whether I'm going to go beyond Mr. Miller.
Okay. Okay. Thank you, sir. And we're certainly not holding you to anything. So we'll take a 5-minute recess. Gentlemen, yeah, we're ready. The board's ready whenever you are.
Okay. I actually have more than one witness left. Probably two short ones and Mr. Miller. I'd like to call Sarah Pilling.
And if you'll raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
And state your name for the record and spell.
Sarah, S-A-R-A, and the last name is Pilling, P-I-L-L-I-N-G.
Ms. Pilling, you're a Radnor Township resident, correct?
Yes, I am.
How long have you been a resident?
I have lived at 29 Garrett Avenue for 30 years.
Okay. And you've been sitting through the testimony tonight, so you know we're talking about 54 Garrett Avenue.
Yes.
And where do you live in relation to 54 Garrett?
My address is 29 Garrett. 54 is across the street, and it's the fourth property further south. Our properties are about 40 feet wide, so I figure I'm about 200 feet from this property.
Okay. And you're in a twin house?
No, I'm in a single.
Okay. From your house at 29 Garrett, can you observe 54 Garrett?
Yes, I can.
So you can see the comings and goings and the porch at 54 Garrett, is that correct?
Yes, and I walk my dog numerous times a day up and down Garrett Avenue, so I pass the house going to the park and coming back.
Okay, now Mr. Leota testified that he's owned this property since 1988, I believe, and it's always been a student rental.
Right.
Can you confirm your observations that it's always been a student rental for as long as you've lived there?
Well, I knew it was a rental because it changed every year. And because they were young and they wore Villanova information jerseys, sweatpants, etc., one could come to the conclusion that they were students, and they were mostly Villanova students.
Okay. And during the time that you've lived at 29 Garrett, what have you observed with respect to noise, parties, those types of activities at this property?
Always knew there were students. My immediate recollection is the last 2 years have been particularly difficult.
Could you describe why?
5 cars in the driveway every day, a lot of noise, trash put out at the wrong time, not in trash cans, in trash bags so that animals would get into them and the trash would be strewn. A lot of coming and going, quickly turning cars around, speeding on the streets. We're a very tight, narrow street, and there's only parking on one side of the street, and you almost have to stop to let the other person go by. So there's just a lot of ruckus and disturbance.
Okay. And you've reported some of this to the township?
Yes, I have. Last year and this year, I noted the cars, the variety of cars, the models, the colors, the make, and the license, because it just seemed to be too many cars in the driveway on a routine basis every night.
Do you know whether the cars, you said continuously, but did you observe the same cars in the driveway, say, over the course of a whole semester at Villanova?
Yes. I had spoken to Mr. Miller and asked him what to do because I was concerned about the number of cars and the traffic that causes. And so on a random basis, but never on a weekend, as I walked the dog, I noted the color, the make of the car, and if I could see it, the license plate number, and I wrote a letter to Mr. Miller and gave him that information of the information at 54. Sometimes they were on the street, and then you can't identify it. But I believe we have parking permits on Garrett Avenue. And if you have a driveway, you're not entitled to as a resident, you're not entitled to a parking permit. I'm assuming, but I don't know, that it's the same for any property that has a driveway. The cars have to be off the street.
Okay. So you got close enough in walking your dog to observe the make, the model. Did you write down license plate numbers also? You did? And how long have you been providing that information to Mr. Miller?
I did it for about 6 weeks, and then I wrote a letter to Mr. Miller, and I sort of gave up because it just seemed like an endless problem, and I didn't know what to do about it.
Okay, the 6 weeks that you did this was when? This year or last year?
Starting about I wrote the letter about the 15th of September, so it had to have been about the first 2 weeks in September. The students move in about the third week in August. It's pretty quiet in the summer, and then it begins.
Okay, other than the vehicles, have you observed more than 2 students on a regular basis coming and going?
Routinely coming in and going to class.
Okay, and you've observed the same 2 or 3 or 4 or 5 students?
Same 3 or 4 girls, yes.
Okay.
They seem to be all females in that house this last year.
Okay, how about prior to this last year?
I don't remember the details of last year.
Okay.
I don't want to focus my life on what the students are doing at 54, but there are times when it really intrudes on the peace and quiet of our neighborhood. We're a very, our end of the street is a pretty tightly knit neighborhood. We shovel with each other in the winter. We look out for each other. We just really care for each other. And so when there's sort of an intrusive element, it's very obvious.
Okay. And how long has this rental been intrusive, as you've described it?
I would say my immediate memory is the last 2 years.
Okay. I have no other questions for Ms. Pilling.
Mr. Foe.
No questions.
Okay. Mr. Economides, if I could recall Officer Gallagher just to address some questions about the chief's email that had license plate numbers in there and whether or not the chief had run the tags or gotten some information. We have now done that. We'd like to, it'll take 2 minutes. If I can
Any
recall
objection?
Officer
He
Gallagher.
has a right to redirect. We can wait till after your case.
This is a hearing. You're not allowed to go make up evidence while you're going along. You
Well,
testify.
wait a minute.
Well,
I object to the characterization of make-up.
You have
I'm
an
not
object-
saying he's falsifying the content, but he's coming up with evidence that he didn't have.
Well,
when he
Mr. Flo, we don't know
testified.
what he's merely asked whether he can recall a witness. I'm simply asking you frankly, I didn't think you'd have an objection. I mean, he has a right to do redirect. If there's other evidence that's come up, whether it's
Fine.
during your case in chief, he can do it after that. But if do you have an objection to him doing it now? Because yes or no?
I have an objection. Yeah, I do, because he sat there and said that he had run the tags. So that's obviously what this is going to be about.
Well, I don't know if that's what he said, but I thought the only thing I heard him ask was whether or not he can call this witness, and I was going to ask you if you would have an objection. John, do you mind waiting until you redirect, or we'll wait till...
Go ahead and call.
I mean, you're going to be able to call him. I would, at that point, I don't see how you would have an objection.
Go ahead and call.
Yeah, I mean, look, it's just about this is a normal course, calling witnesses. You'll be allowed absolutely the same leeway if you need it. But I would overrule the objection at this point, especially if you're allowing him to call it. John, go ahead and call.
Officer Gallagher, please. Okay, Officer Gallagher, you're still under oath. You sat here through Superintendent Colorado's testimony, and regarding the email that was submitted as Exhibit T13, there were some questions regarding the second page of T13 where there were license tags identified in there.
Yes, sir. I was present when they were.
You heard all that testimony.
I was also present the day with the superintendent when these registrations were taken down.
Now, do you have information regarding the ownership of the 4 vehicles that are identified in that email?
I do, all 4.
Okay. Could you describe?
Objection. This is after the fact. We're here. We've already had the testimony, and the testimony's been concluded. The evidence wasn't available then. You can't stop the proceedings and ask for a 10-minute recess and go find out what the evidence is.
Actually, well, I frankly, I don't know that he can't do that. I mean, if he's not making up evidence, he certainly isn't doing that. It's facts that exist. You raised the issue, and frankly, you brought it up. We're sitting on top of the police station. They have the ability to run this.
I did. I brought it up to show that they hadn't bothered to do it.
We're just trying
to this point,
and I think he's responding to that. So John, if you want to respond to that,
that's all it is. Mr. Flail brought it up. He seemed to be interested, knowing who the owners are. So we had the opportunity to do it. The hearing's still ongoing. I mean, the board, I think, has a discretion to admit this or not admit it, and we're responding to Mr. Flail's questions regarding the tag. So,
all right, so with that, we'll overrule the objection. The objection's noted. It's unfortunately or unfortunately, we're sitting on top of the police station, and they have the ability to do this. So, and I think they have the right to do it. So, with that, we'll continue the hearing. And John, go ahead.
Okay, Officer Corporal Gallagher, could you just describe then in the T13 what you found in terms of ownership of those four vehicles?
Starting at the top, the Nissan New Jersey tag, Z Zebra, T Tango 24H Hotel. It's a Nissan Rogue, and it's registered with James Salvio out of Margate, New Jersey. Second vehicle, the Volkswagen, New York registration, F. Frank C. Charlie V. Victor 9701, comes back to a Gregory Lynch out of Amityville, New York. The third vehicle, BMW, Pennsylvania Hotel, H Hotel, F. Frank and Nancy 3716, comes back to a Nolan Olson Associates out of Dallas, PA. And the fourth vehicle, New Jersey, V Victor G Golf R Romeo 37 J Juliet. It's a Honda CRV back to a Frank Mucher or the Mucher out of New Jersey also.
Okay, the BMW, you said it was titled in a corporation?
That is correct, matching the name of Olson.
Olsen?
Correct.
Okay. Nothing else for Corporal Gallagher.
Mr. Flail?
No cross.
I'd like to call Bill Miller.
Sir, if you'll raise your right hand, you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
Okay. State your full name for the record, please.
William Miller.
Okay, Mr. Miller, what is your current position with Radnor Township?
I'm a codes official with Radnor Township.
And how long have you been in that position?
Approximately 13 years.
And have you held similar code official positions anywhere else?
Yes, I have. I was worked for the Borough of Westchester for almost 10 years.
Okay. And as the code official, what's your general job description and job duties?
It's the enforcement of the property maintenance codes and building codes of Radnor Township, and also certain ordinances such as the rental ordinance.
Okay. So with respect to, we've got a lot of testimony and a lot of documents tonight regarding 54 Garrett. Did you do any kind of review or research regarding prior violations, whether code, zoning, or any other ordinance violations regarding this property?
Yes.
And what did you find?
On our computer system, we keep track of complaints that are registered typically by residents here, and I printed off a list of the complaints that had taken place at 54 Garrett Avenue over a course of time, I think basically from 1991 to the present.
Okay, I'm going to ask that list be marked exhibit, I believe it's T14.
And I'm going to object to this on the same basis as I did of the first witness. This is beyond the scope of the citation.
And John, I'm assuming your response is the same as the objection that was raised with that first witness.
It's for the same reason as all the other history of violations that have been previously
And Mr. Flail, for the same reason, I'm going to overrule the objection. It goes to what his investigation was. The ordinance talks about what he can look into, and I think they have it's certainly relevant and have a right to present it.
Thank you.
But then the objection's noted for the record, and it's a continuing objection.
Hey, Mr. Miller, you're looking at what's been marked as T14. Could you describe on there what that represents?
This is a list of the complaints that were printed off of our computerized system regarding 54 Garrett Avenue.
And would you go through, well, let me just do it this way. Maybe it'll be a little bit quicker. The first violation, type of violation, is dated September 11th, 1991, correct?
That's correct.
Okay. And that indicates that it's a violation of the zoning ordinance, and it says under complaint, occupied by more individuals than are allowed under the ordinance, right?
That's correct.
Okay. Do you know what the disposition of that complaint was?
No, I do not.
Is it fair to say that that was a violation of having too many students?
Objection.
At this particular.
If he wasn't directly involved, he can't characterize it any more than what's printed there.
Do you know, Mr. Miller, whether or not that involved a violation of too many students in this house?
Actually, I do not.
Okay. The next violation is July 23rd, 1992. That's a property maintenance violation, correct?
That's correct.
Okay. Do you have any personal knowledge or know what the disposition of that was?
No.
Okay. September 8th, 1992, again, is a zoning violation. It says more than one unrelated individual in housekeeping unit. Do you know whether that's what type of zoning violation that is?
No, I do not.
Okay. How about 1995? We have also, again, more than two unrelated in one housekeeping unit.
No, I do not have any knowledge of that one either.
Okay. The rest of these list either property maintenance, or rental properties or zoning violations of the various chapters of the Township Code, correct?
Yes.
Are any of these, and how long have you been working at Radnor?
Since September of 1999, minus 1 year when I was laid off,
Okay.
which was from 2009 to basically June of 2009 to June of 2010.
Okay. Are any of these, were you involved in the citations involving any of these?
Yes, I was.
Which ones?
On October the 8th, 2001, 3 unrelated living at the property. I was involved in that one. The next one, 8102, the violation of a noise ordinance. I was involved in that one. And 10902, disruptive conduct. I was involved in that one. The October the 11th, 2006, too many unrelated individuals living at the dwelling. I was involved in that one. The 2007 violation, 9707, too many unrelated living in the dwelling. I was involved in that one.
Okay. Do you recall what the resolution was for the ones that you were involved with?
One of the violations, I believe the 07 violation, I issued a citation for that. I can't recall the exact outcome of the citation. The others, we issued notices of violation of the zoning ordinance to the owners, to Mr. Liotta, and to executive property. And I believe we investigated those afterwards and found that they appeared to have been resolved.
So that they came into compliance at some point?
They appeared to come into compliance. Typically what we do is we'll issue a notice, a zoning notice of violation. I believe one of these may have gone to the zoning hearing board, but I'm not sure what the disposition ended up with that one. Okay. One of those I did issue, like I said, in 2007, a citation for too many unrelated people.
Okay. Well, let's talk about the March 2012 suspension of rental license. I don't know whether that's been marked as an exhibit yet or not, but I guess we should do that.
It is not.
Mr. Miller, do you have additional copies of that with you?
Yes, I do. Would you like them?
Yes.
No, I have it. I just want to mark it.
Yes.
Okay, Mr. Miller, you're looking at what's been marked as T15. It's a March 27th, 2012 suspension of rental license for violation of the rental housing code, correct?
That's correct.
Okay. Would you, it appears to me that you've cited here Chapter 226, Section 226-A, D, and on the second page you've cited 3 violations of other ordinances. Would you describe how you came to file this violation notice?
This violation notice was filed due to the fact that in October we had a zoning violation there with more than 2 unrelated people living at the property based on some information I had received from Superintendent Colarulo and his visit to the property. Subsequent to that, we issued a formal warning letter. Then on March 15th, 2012, there's a typo in my letter that I'd like to just bring to your attention that it's not 2011, it's 2012, March 15th. That, again, Superintendent Colarulo went to the property and again found that more than 2 unrelated people were living at the property.
Okay, and we've had testimony regarding both the October 2011 incidents and the March 2012 incidents. So let me just go back, though, to October 2011. You issued both a zoning violation notice under the zoning ordinance that governs student housing now, and you issued a formal warning letter under the rental housing ordinance, correct?
That's correct.
Okay. Now, did you have any discussions after that formal warning letter was sent with Mr. Leota or Mr., I think his partner is Mr. Sparango? Sparango.
Yes.
Did you have any discussions with either of them at that time?
Yeah, on October the 20th, 2011, I met Mr. Leota and Mr. Sparango at the property to perform a property maintenance and inspection to verify that, in fact, the violations of the zoning ordinance had been resolved, and also to make notation if there were any violations of our property maintenance code.
Okay, was it just the 3 of you at that inspection?
No, actually there was a 4th, Mr. Daly, one of our other inspectors was there also.
Okay, and
Ray Daly, that is, I'm sorry.
The purpose of that inspection was to do a walkthrough of the property?
Do a walkthrough of the property, check the general appearance of the property, and also check the occupancy of the property.
Okay, you did walk through the property?
Yeah, we went through the entire property from every floor, including the basement.
And what did you observe when you walked through the property?
We had several property maintenance violations at the property, and also we observed that 4 of the bedrooms were occupied. Actually, the bedrooms were all occupied. The 3 bedrooms on the second floor each had a bed in it, and the 3rd floor was occupied. There were personal belongings in the bedrooms, clothing, pictures, makeup, that sort of thing in each one of the bedrooms where we found the 4 beds.
Okay, so there's 3 bedrooms on the second floor.
That's correct.
And there's a attic converted bedroom on the 3rd floor.
On the 3rd floor, that's correct.
And you were in all 4 of these bedrooms?
That is correct.
Okay. And you observed beds, clothing, dressers, toothbrush. I mean, did you observe 4 different sets of belongings in each of the bedrooms?
Yes.
Okay. So as a result of that inspection, what happened next in terms of code violations?
We issued a letter on the spot to Mr. Leota and Mr. Sparango for the property maintenance violations, and we discussed the occupancy of the property at that time, that it still needed to be corrected.
And what was their response? Did they correct it?
Actually, we did not get back into the property until they delayed several times for me to get back in. I did not get back into the property until April the 10th, 2012, when I did a subsequent follow-up inspection with one of Mr. Sparango's employees.
Okay. But this was after the March 2012 incident that we've had testimony about already.
Yeah, yes, that's correct.
Okay, so between October 2011, March, April 2012, you were attempting to visit the site to see if it had come into compliance?
I had called Mr. Sparango a couple times, and I don't believe I had called Mr. Leota, but I had called Mr. Sparango a couple times. Some of that got delayed because of when the students were on semester break, so we couldn't get into the property at that point. They had to take some time to finish the violations, so we made an appointment in April to do that, to take a look and verify that the violations were resolved.
Okay, now, Mr. Leota testified tonight that he was never aware of ever being more than 2 students in this house. Do you recall that testimony?
Yes.
So he was there that day, and he saw the 4 beds
Yes.
and what appears to be 4 different people living in the 4 bedrooms. Did he deny that there were 4 people living there that day?
No.
Okay, so he realized there was a zoning violation that day.
Objection. He's asking for a subjective conclusion by this witness as to what Mr. Leota knew or didn't know.
Without getting into his mental state, if you could rephrase it, please.
Okay. Was it clear to you when you were there with Mr. Leota and Mr.
Sparango? Yes.
I'm going to mispronounce it. That there were 4 students living there?
Yes.
Okay. Have you been in that, prior to the fall of 2011, have you been in that rental property before for an inspection?
Prior to the the October 20th?
October, right.
Probably the last time I was in the property was probably, without looking at our records, would be the September the 7th, 2007 complaint that we had too many unrelated living there, at which time we had served an administrative search warrant to the property.
Okay, so you were in the property back in '07?
Yes.
And was there more than 2 students living there at that time?
Yes, I believe at that particular complaint there were 4.
Okay, was Mr. Leota or his partner with you at that time?
No, that was an administrative search warrant that was served early in the morning, based on a complaint from residents in the area.
So that was a surprise inspection by the township?
Yes.
Essentially, and there were obviously 4 students there, is that right?
Yes, yeah.
Okay. And notice was given at that time to Mr. Leota?
I believe that was the inspection that I issued a citation to the owners for.
That's on Exhibit T14. September
Yes.
7th, 2007?
Yes.
Okay. So there was a citation there at that point, unresolved, and again in 2011 you have the same situation with too many students there, correct?
That's correct.
Okay, those 2 times prior to 2007, were you ever in that building?
Yes, the October the 11th, 2006 complaint and the October the 8th, 2001 complaint. In both of those incidences, we served administrative search warrants and found more than 2 unrelated people, more than 2 students living at the property.
And is it fair to assume Mr. Leota and his partner were noticed at that time? They received a citation of some type?
They didn't receive a citation. They received zoning violation notices.
Were any of those ever appealed?
No.
As far as you remember, is that right?
As far as I remember, no.
Okay. Okay, going just based on the T15, which is the March 27th, 2012 violation notice. So you've cited in there in paragraph 8 on the 2nd page the zoning violation notice, the formal warning letter, and then the most recent noise incident violation for which there were citations issued as one of the reasons why you issued this suspension. Is that right?
That's correct.
Okay. Now, you also cited in here on the front page, paragraph 1, I guess it's paragraph 1 under 226-8D, failure to correct a violation that applies to the premises within a time period set forth by the code official. That represents your ability under the ordinance to set a suspension time period, correct?
I believe so, yeah.
Okay. Under the same, on the front page, it says failure to take steps to remedy and prevent violations of rental units as required by this article. What were you referring to there?
There, I was referring to the number of unrelated students living at the property.
Okay. Not just from 2011 or previous to that?
Basically from 2011, from the October violation, notices of violation, and the fact that it would appear that nothing was done to bring the property in compliance with our zoning ordinance based on the October the 11th notice that I issued to him.
Okay. And that's the most recent notice?
Yes. I'm sorry, October the 11th, 2011.
Now, Mr. Flail, in his appeal on behalf of his client, suggests that you imposed a one-year suspension because that would have the effect of prohibiting any future rental based on the township zoning ordinance. Was that a reason why you imposed a one-year suspension?
Absolutely not.
Well, what were the
reasons
why you imposed a one-year suspension?
The reason was because of the disruption that had been caused to the neighborhood in early October, and then the fact that the owners had not taken any steps to actually correct the violations that we found at the property.
Okay. Did you take into consideration this history of violations in your prior experience in visiting the property?
My prior experience was that the property appears to be a habitual problem with too many unrelated people living there.
Objection. That answer is not responsive to the question. Question was whether he took into consideration in issuing the March 27th letter the prior violations.
I think it was a long-winded yes with an explanation, which I think he's allowed to do. But if he can give us his response to the questions, Phil's ready. If he can give us a yes or no, and if he wants to give his explanation, he can do it.
Oh, he's already answered the question.
Just to confirm if it's a yes.
That he took that
into consideration.
He took this
Yes.
T14 into consideration.
Yes, I would say so.
I have no other questions.
When did you develop the list that's in T14?
This particular list, Mr. Flail?
Yes.
That list is a list that's added. It's a calendar list that's added whenever a complaint comes in. The complaints are entered into our system.
But when did you access it and print it out?
Or print this particular list out?
Yeah.
That was today.
Today.
Yes.
So when you issued the citation, your March 27th letter, T15, you didn't cite any of those incidents in this letter, did you?
No.
And as a matter of fact, you testified earlier that they had all been resolved.
I believe that was correct, yes.
Right. So then,
excuse me, with the exception of one, I didn't know the disposition of the citation for the 2007 violation.
the trash in the front yard or the too many unrelated?
The too many unrelated.
You don't know what happened there?
I don't remember what happened with the citation, whether the owner paid it or he appealed it in court. I believe he just paid it.
So in any event, it wasn't the basis for the issuance of this March 27, 2012 letter, was it?
I would say not exactly, no.
Your letter, T15, is based on what it says. The incidents that occurred in October 11, 2011, and what occurred in March 14th or 15th, 2012.
Not exactly.
Well, isn't that what it says?
That's what the letter says, yes.
Okay, that's what the letter says. That is the basis that you wrote that said the reasons that you were suspending the license.
That's what the letter says.
That's what the letter says.
Yes, sir.
And under the rental housing ordinance, is it left for the owner to ferret out what other basis there might be behind the letter? They have to respond only to the letter. Isn't that correct?
I would say so, sir.
Okay. Now, let's talk about the October 11, 2011 incident where you've said that there were more than 2 unrelated individuals living at the property. What was your basis for making that finding?
I'm sorry, could you ask that again, please?
Well, in other words, how do you know there were more than 2 unrelated people living in the property?
From information I received from Superintendent Colarulo.
Okay, so you didn't make any independent inspection, correct?
No, the inspection I made was afterwards.
Right. So, and you don't know from your own knowledge whether or not there were more than 2 unrelated people living in the property at the time, correct?
I'd say so, yes.
You acted on the police superintendent's information.
Yes.
And you don't know if, in fact, there were more than 2 unrelated people living in the property on October 11, 2011, as to who those people were, do you?
I believe it was the information was in a police report. I don't have that information here at hand right now.
Do you have the police report here on which you base this?
He stated he didn't.
Do
you know
Mr. Flair,
that
and we talking about the March 27th?
No, we're talking about October 11th.
Right.
Just want to make it clear.
Do you know the identities of the people who were allegedly more than 2 unrelated people in the property? In other words, people who were not tenants who were living there.
I know 3 of the names, sir.
You know 3 of the names?
Yes.
From October 11th?
Yes.
Who were they?
Julia Lynch, Maureen Mukel, and Marissa Brown,
And how do you know that?
because it was in the police reports.
On October 11?
I believe so, sir.
A few minutes ago, you just testified you didn't know the name of the people. You just acted on the police report. Now, which is correct?
I know those 3 names were occupants of the property.
On March 15th.
Well, can
No.
we? We're
changing dates, yeah.
We're jumping around.
Because
and-
I wasn't clear either, and that's why I wanted to make
I
it clear
asked-
for the witness and
well,
frankly for the board.
I thought the question was very clear. I asked him, and he said he did not know who the people were that were allegedly more than 2 unrelated people on October 11, 2011.
I don't.
That's what he
well,
said.
I don't. We can read it back, but I don't think he ever answered that question.
And I think it's irrelevant. Let's just make it clear, because I think there's obviously some confusion going here, because I was a little confused as well as to exactly what we were talking about.
Let me ask it again then. Do you know the names of the people who were occupying the premises on October 11?
Yes.
And how do you know their names?
From the reports I received.
You didn't determine their names on your own then?
No, sir.
And where is the report on which you based your knowledge?
I can't answer that question right now.
Okay, so you don't recall on your own what their names were, you just remember those names being in a report that you don't have.
I think you're asking the same question. Do I recall the names or do I know the names? I know the names.
And let's go back to some basic information. How long have you been administering the residential housing ordinance,
Since its enactment.
which was?
I believe it was in 2001. I don't know the exact date that it was adopted. I could get that for you if you'd like, though.
And a new ordinance was passed in 2011, is that not correct?
Yes, sir.
So you have administered that one for about a year, correct?
Yeah, I would say so, sir.
All right. How many prosecutions under the rental housing ordinance have occurred, both under the 2001 ordinance and the 2011, if you know?
I don't know off the top of my head, but of suspensions that I have personally done, I believe this is the 4th or 5th.
All right. And were all of them or any of the others done under the 2011 version of the ordinance, or were they all under the prior version of the ordinance?
This is the first one under the 11.
Now, does your department conduct regular routine inspections of rental properties?
Yes.
And how many times have you done routine inspections of 54 Garrett Avenue?
I don't know that answer off the top of my head.
Have you ever done one?
Yes.
Other than the one you did with Mr. Liotta and Mr. Sparango?
Yes.
Okay. Do you remember approximately when that was?
I would probably. I would say it was somewhere between 2005 and 2009. That's my best guess. I don't know the exact dates without going back to the computer and checking that.
Now, how often do you do these routine inspections?
Routinely is what the ordinance says.
Well, how many times have you been in 54 Garrett Avenue for a routine inspection?
Once again, sir, I don't know that without checking the computer.
Objection. He just asked and he answered this question.
Well, he hasn't really answered it, which is why I asked it. But
Well, he doesn't know.
have you inspected other properties on Garrett Avenue?
Yes, sir.
Have you found any violations in any of the other properties?
Yes, sir.
Have you issued any citations on any of those properties?
I believe so, sir. But once again, I'd have to check our records.
Okay. Now, does the ordinance contain any criteria for when you must suspend the license of a rental property?
When I must,
Right.
I don't know the answer to that.
The ordinance says you may, does it not? If there are 3 or more violations?
Can we direct the witness to what ordinance, what section? I mean, it sort of speaks for itself. If we're going to argue about whether it says must or may, I'll concede that it says may.
Mr. Flail, if you can be more specific, but I think the questions are appropriate. I mean, he's a code official. I don't want this to become a gotcha moment either, and quizzing him on the ordinance. If you can point to what you're getting at, I agree that would be fair.
What I'm getting at is this. What, if any, objective criteria are in the ordinance, or have you otherwise developed to determine when you are going to suspend a license or when you are not?
What objective criteria have I developed? Typically,
What's in the, first of all, let's take it in parts. What criteria are in the ordinance that, if any, that dictate when you must suspend a license?
I don't think it says we must suspend a license as
All right.
the
So
solicitor
there
has
aren't any.
stated.
There aren't any. Have you developed any criteria administratively as to what types of violations will result in the issuance of a suspension notice such as T15?
Usually what I have applied is the formal warning process to where we have 3 violations of any ordinance of the township, and then a notation is made such as the formal warning letter I issued to the owner on October the 11th. And then if there's subsequent violations of that ordinance at that time, we may suspend the licenses, which I believe the letter says.
All right. So in this particular case, 2 of the violations that you used to make up your 3 occurred on October 11, 2011. Is that not correct?
That is incorrect.
Look at paragraph, the second page of your letter. Under Chapter 226, Section 226-8D,
This is Exhibit T15.
T15.
Okay, I wasn't
8.
sure which, yeah.
Well, it's the top of the second page. You list 3 violations there. Correct?
Yes,
2 of them are on October 11.
yes.
And one of them is on March 15th.
Yes.
Now, is it not a fact that the violations that you allege under 8B were resolved?
No,
They were not resolved?
not to the best of my knowledge.
When you were there on the subsequent inspection, when did you go in? April 10th, did you say?
Yes, sir.
Okay. But you issued this letter on March 27th.
Yes, sir.
Did you have any reason to believe on March 27 that these the violations that you've set forth in 8B were still ongoing, or did you just say
I
since
believe
you
they were still in existence based on the March 15th inspection by Inspector Colarulo when he actually spoke to the tenants there at the property. So based on that, that is why the suspension was issued.
If all three violations occurred on the same day, would you still suspend a license for a year?
I'm sorry, you're asking me to draw a conclusion. I don't believe I can.
It's a hypothetical question, yeah.
Yeah, I mean, I don't know, you can, I'm not going to allow you to ask him hypothetical.
He's not?
He isn't, yeah, he's a fact witness. He's not being produced as an expert witness.
So basically, when you're in deciding whether or not to suspend a license, you pretty much are on your own as to whether or not you're going to suspend the license or mete out some lesser punishment in the case where there have been, as you say in this letter, 3 violations.
No, sir, that is not true.
Well, then what do you do?
I discuss it with the other code official here. I discuss it with my supervisor. I discuss it with the township manager. I discuss it with the solicitor, Mr. John Royce.
But there are no criteria which you go down a list and you say, this has happened, this has happened, this has happened, and therefore, in this situation, we will or will not suspend the license. It's pretty much case by case is what I'm getting at.
I would say it is case by case, yeah, because each case can be different. The circumstances for the suspension can be different reasons.
And in this case, it appears to me, you correct me if I'm wrong, that your primary reason for suspending the license was the unresolved conduct of the students, correct?
No, sir.
It wasn't?
No, sir.
What was it?
As stated in my letter, the investigation into noise found 4 students living at the property in violations of item number 1 and number 2. That's item number C in my suspension letter.
All right, the students did that, not the owners.
The owners did not correct the violation of too many unrelated people living at the property, sir.
I understand that, but the conduct that resulted in the violation was the conduct of the students, not the owner. The owner was after the fact. The students, assuming that everything you said was correct, the students, the tenants, allowed more than 2 people, unrelated people, to live in the property.
Once again, sir, I do not know the answer to that question. I don't know what the students allowed.
Well, they were there, were they not? And the students were the ones who were living in the premises, correct?
The students were the one living in the premises,
Right.
yes.
And the conduct, the noise violations, and the other violations we've heard about here tonight were the acts of the students, were they not? The trash on the curb, whatever else was brought up.
Yes, sir, and our ordinance
right.
says the owner is responsible for that conduct.
I'm not arguing that point for right now. My point is this. The students are the ones who did the act. However, you saw fit to suspend the license, the ability to rent the property to anyone for a year. Did you take into consideration, maybe you should have said something to the effect of, well, we should prohibit them from renting to students for a year instead of imposing a suspension where they can't have the premises occupied at all?
Yeah, we took that into consideration.
What is the benefit to the health, safety, and welfare of the general public of having those premises unoccupied for a year?
Because these particular owners do not regulate their occupants, and they cause great disruption to the neighborhood. We get several complaints from the neighbors. They cause problems for our police and the code officials, and basically it's a very disruptive property.
Okay,
because
so
they do not control it.
And isn't it a fact that a vacant property is also a problem for the general public's health, safety, and welfare?
Not if it's properly secured, and the owners keep an inspection at the property. They make sure that it's secured. They make sure that it's maintained.
Well, wasn't there, in fact, an incident on April 23rd or on or about April 23rd of this year where a vacant house on Garrett Avenue was burglarized?
I had no knowledge of that, sir.
You have knowledge of the police reports that pertain to this particular property, but you don't keep track of things like that?
I had no knowledge of that particular problem, sir.
It was published in the local newspaper.
I don't receive that local newspaper, sir. I do not live in the township.
When you first issued your letters, I forget the numbers, I think they're T3 and T4, the formal warnings back on October 11, 2011,
Okay.
did you have any contact with the owners at that point, subsequent to that letter?
Prior to that letter, we had a meeting with Mr. Liotta here at the Township building. I believe the superintendent testified to that matter.
And were you aware of the fact that they sent a letter to the tenants and told them that any further violations would result in their eviction?
I'm sorry, would you repeat that, please?
He said, were you aware that there's an exhibit up there, it's A1, the letter that was sent to the tenants advising them that if there were any further violations that they would be evicted?
Yeah, I received a copy of that.
So you were aware that steps were taken?
I'm aware that a letter was issued, yes.
Okay. Did you, after that, take any steps to determine whether or not the violations were still going on?
I attempted to enter the property several times. I did not get back in there until April the 10th.
Did you ever go past the property and just observe what was going on there?
Yeah, I believe so, sir. But I don't recall the exact dates, but I believe I was past the property.
All right. And what did you observe when you went past?
One particular instance was we got a report that one of the occupants of the property had actually crashed through a window, had received a cut, and broken a window out of the front porch. So there was a police incident report regarding that. I don't remember the exact date. I think I have a copy of it over there at where I was sitting. And I went down to the property, observed this particular problem, called Mr. Sparango concerning that because there was glass all over the place, and requested that the property be cleaned up.
And did they clean it up?
Yes, sir, they did.
And generally speaking, isn't it a fact that the owners were pretty cooperative with you when you asked them to ask for something to be done? They did it.
Yeah, when I called them or issued a notice of violation, yeah, typically,
Right.
yes. On the property maintenance issues, I would have
Right.
to say so, sir.
Okay. So the property maintenance issue still is one of the criteria that you use for issuing the suspension notice, correct?
Could you say that again, please?
Going back to T15, 8B, second page. Failure to take steps to remedy and prevent violations of rental units and failure to correct violation that applies to the premises within a period of time set forth by the code official.
Okay.
All right? What violations are we talking about there?
Zoning violation.
Zoning
Too many unrelated
violation?
people living at the property.
All right, so then you're taking three incidents, you're making three incidents out of the same thing. More than two unrelated people living in the premises at the same time, are you not?
I wouldn't say that, no.
Well, you just said that it was the occupancy issue was what you were covering in 8B. In 8A, you say zoning violation notice, more than two unrelated individuals living at property. And the same thing on March 15th. It's not all of what you said about on March 15th, but it's incorporated in there.
Well, this is merely a summation to show that they did not correct the violations, the zoning violations. And that the formal warning letter was issued, that was item B.
All right, but in the ordinance says that if there are three violations, that you can issue a suspension order. You may issue a suspension order.
That's one of the criteria, yeah.
All right. But that's the criteria that you cited in T15, the March 27, 2012 letter, is it not?
That is one of the criteria. I also cited the criteria that they didn't correct the violations, which was the too many unrelated people. That's item number one on the first page.
I'm sorry. It all goes back to there were too many unrelated people in the property.
It goes back, yes, sir.
That's the reason that you did this.
Yes, sir.
And so there really was only one violation that you're after, the unrelated people.
They did not correct that particular violation.
Right,
That is
so
correct.
it's one, not three.
I'm sorry, Mr. Flau, I don't see your point.
And how much were you affected by the fact that, as is obvious from the testimony here tonight, that the police considered this property to be a pain in the neck and a source of a number of complaints in deciding to issue the suspension order instead of invoking some lesser punishment, such as a fine or...
I would say hardly at all. I took that into consideration, but hardly at all.
You
That
took
was
it into
may have been
consideration.
one of the reasons.
And the notice that you mailed out giving the public notice of this hearing tonight, you prepared, correct?
Well, I had some input into it. There was several people that had prepared the order.
And the notice clearly says that it's for more than two unrelated people living in the premises, correct?
I'm not sure what that says, Mr. Flau. I don't have it here in front of me if you'd like to present it to me. Yeah, I have copies. Want to get them?
Mark that A2. I can see from here. I'm going to read the second sentence of this. This hearing is regarding the March 27, 2012 notice of violation for the suspension of rental license for renting a dwelling unit to more than two student tenants at the aforementioned I'm sorry. I'll start over. This hearing is regarding the March 27, 2012 notice of violation for the suspension of rental license for renting a dwelling unit to more than two student tenants at the aforementioned property in violation, and it cites the provision. That's the basis for the suspension,
Yes, sir.
correct?
Yeah, I would say so.
Okay. Not all this other stuff that we've heard about. That's the basis.
Well, there was a formal warning letter issued also, but that was the basis for the suspension.
But it also applies to more than two unrelated students.
You mean the suspension?
Right.
Yes.
So that's the reason you suspend the license, because there were more than two unrelated students in there. Now, between October 11, 2011 and March 15, 2012, do you have any knowledge as to whether or not the property continued to be occupied by more than two unrelated students?
No.
Okay. So you don't know that possibly the students could have been moved out and moved back in, or different students were there?
Sir, could you ask that question again, the previous question?
Okay. You don't know between 2011 and in October 11, 2011 and March 15, 2012, whether or not more than two unrelated students were continuously in the property.
Yeah, I do that. I do know that.
How do you know that?
Because I did an inspection on October the 20th, and we found 4 beds in the property. The property was clearly
All right.
occupied by more than two people.
Well, how do you know that it was that? How do you know just because there are 4 beds? You know, somebody could be using 2 rooms. How do you know that it was that there were 2 other people in there?
I think it was fairly obvious by the conditions that I saw in each of the bedrooms.
But you didn't see any of the 4 people in there at the time, right?
Now, these landlords are very astute. So when I inspect the properties, none of the tenants are there.
So you didn't see them.
No, I did not.
So you really don't know who was there or how many, do you?
I would say there were 4 unrelated people living at the property based on what I saw.
Assuming from what you saw as far as the items of clothing and personal property and so forth that were there at the time.
Yes, sir. Based on 20 years' experience as an inspector, I would.
And do you know that if you were right that there were 4 students living in the property at the time, do you know? In fact, I'll ask it the other way. You really don't know that continued until March 15th, do you? Because you weren't back in the property.
That's correct.
Those students could have moved out. There could have been other students that moved in and moved out. You just don't know. But you issued T-15 on the basis that it was a continuing violation, didn't you?
I was familiar with one of the names, that being Julia Lynch, who's not on the lease. That was the same person that was issued a citation on September the 13th for the first noise violation that I issued my formal warning letter for, and she was also an occupant of the property when Mr. Colarulo was there, and he would question who lived there, and I believe that was one of the occupants. So that in itself shows that there were 3 unrelated living there. And Ms. Julia Lynch lived there on September the 13th, and she was also there on the property on March 15th when Superintendent Colarulo was at the property.
But supposing that in the meantime, the owners of the property had made sure that those people were removed from the property and were no longer living there, and then they subsequently moved back in. Can you say, sitting here tonight, that definitely didn't happen?
No, I cannot.
So you acted on the assumption that they had been there continuously that entire period of time.
I acted on the facts, sir, that Mr. Colarulo was supplying to me.
Let's go back to this, what was it, an incident report that you mentioned earlier in your testimony was the basis that you knew who who was living in the premises on October 11, 2011?
This has been asked. This has been answered.
I'm
We went through this. How do you know who was there? He
gonna-
confused the dates from October to
Well,
March last time.
I think there's a lot of dates. I'm going to allow him to ask this. I don't know that it has been. He hasn't gotten the question out yet, so let's see what he wants to ask.
Do you have the document on which you are concluding? Do you have a copy of it?
Objection. He asked that before, and Mr. Miller said he did not have the police report. He said he knew that there were 3 individuals. He named them from looking at police reports.
Yeah, I believe he did say that he doesn't have the reports with him,
we
but
take a recess and let him go look for that, just like they look up the
We're not-
license plates?
We're not going to go looking for that.
if you want to ask him if he has it, I think he's already testified he
So I'm asking
doesn't.
him, do you have it? Do you have a copy of that police report?
Can I step over here for a minute?
Sure.
No, I do not.
Okay. By the way, are you aware that an empty residential property cannot be insured?
No.
Right. You want me to stop on this guy then? I'm not getting very far. That's all I have.
Mr. Rice, any redirect?
Couple questions just for clarity purpose. Mr. Miller, do you have the ordinance in front of you?
Yes, I believe I have a copy here.
Okay. On page, or under section 226.8C, there is criteria listed that the code official, it says, shall consider when applying discipline. Do you have that in front of you?
Yeah, it says when applying discipline under this section, the code official shall consider the following criteria under item C. And there's 7 items listed there. Is
Right.
that correct?
And then D says any of the following may subject an owner to discipline, and there's a list of 9 criteria there, or behaviors that could result in discipline. And I think Mr. Flaile's focused on number 9, which talks about 3 violations of the ordinance. But there is other criteria, is there not, in this ordinance?
Yes, that's correct.
You don't have any unwritten criteria that no one knows about that you utilize? Do you rely on what's in this ordinance
Yes.
before you issue any discipline?
That's correct.
Okay. Mr. Flail also talked a lot about your T15, which is your March 27th, 2012 suspension letter, and on the second page, there's an A and a B and a C, correct? The three, he described them as 3 ordinance violations, 2 of which occurred on the same day.
Yes.
Okay, you remember those questions he asked you?
Yes, I do believe so.
Okay, now A is a zoning violation notice, and that was something that you issued in October 2011, which was never appealed, correct?
That's correct.
No zoning hearing board appeal, so that stands basically as a violation notice that has gone unappealed under the zoning ordinance, right?
Yes.
Okay. The second one references your October 11, 2011 formal warning letter. Do you have that in front of you? It's Exhibit T3.
Yes.
Okay. Now, in that formal letter, you've listed in paragraph 8 a September 13th, 2011 citation, a September 28, 2011 citation, and then the October 11th, 2011 citation. 3 violations in this letter itself for your formal warning, correct?
Yes.
Okay. So, to the extent Mr. Flail thinks there's only one violation here, you've got the October 11th zoning violation, you've got the October 11th, 2011 formal warning letter, which includes the zoning violation and 2 other violations from September, correct?
Yes.
And you've got the March 15th violation there.
Yes.
Okay. Based on your experience and background as a code enforcement officer, was it your opinion in March 2012 that there was sufficient grounds under the ordinance to issue this 1-year suspension?
Yes.
There was also some questions of you regarding the students and how you knew who were there, and I think you clarified that regarding the September. Actually, it's referenced in your formal warning letter, the September 13th and September 28th violations, but my understanding from your previous testimony that based on some police report, you knew there were at least three students living there. Is that right?
That's correct.
Okay. And the same 3 turn up in March, even though Mr. Flail suggested they magically disappeared and then they showed up 6 months later, but they're the same 3 from September to March, correct?
Yes.
Okay. The ordinance also does it not require certain things on the owner of a rental property in Radnor Township, Section 2263 talks about owner responsibilities. Are you familiar with that section?
Yes.
Okay, so not only, and there was some suggestion that, the tenants were the bad behaviors and the bad actors here, and you overstepped your bounds because they were the ones that were in violation and did all these things, and that the owners somehow are not responsible. But there is a specific section in here which states that every owner is responsible for regulating this is 2263C. Every owner shall be responsible for regulating the proper use and occupancy of rental units and for regulating the conduct and activities of their tenants and guests. So the ordinance does contemplate that not only the tenants and or the owners could be cited, could be penalized under this ordinance.
Yes.
Okay. And I think you also previously testified that you have issued violation notices and suspensions in the past for other rental properties?
Yes.
Okay. You're not singling out Mr. Leota
No.
because of a couple instances, is that correct?
That's correct.
I have nothing else for Mr. Miller.
On that last line of questioning, what other suspension notices on what other properties have you issued?
There was one on Petrie, which I suspended his right to rent to students because he hadn't rented the property to a student for over a year. There was another property that was, I suspended his right to rent to students on Conestoga Road. That property is still empty. There was a property on Callanan Avenue who was renting his 2-unit building to more than 2 unrelated in each one of his 2 units. I suspended his right to rent to students, I believe for, I don't remember the period, but that property eventually, subsequent to that, he sold that property, is now owner-occupied in 1 unit, and there's a family living in the 2nd unit.
Okay, so in that, just dealing with that Callanan Avenue, was that the one you were just
That's
testifying
one, yeah,
about?
that was Callanan Avenue
Right,
was
so
one, yeah.
you had violations based on conduct that students did, and you only suspended the rental license for renting to students, correct?
That's correct.
Here, you suspended the rental license for renting to anybody.
That's because the disruption was greater than just 2 unrelated, more than 2 unrelated living at the property. There were several other problems going on at the property. The noise violations, the frequent police calls there.
Well, you testified earlier that none of that, although you consulted with the other departments, none of that input really affected your decision. So if that's the reason that you suspended the license for everything instead of just students, it did enter your decision, didn't it?
I'm sorry, I don't understand the question.
On Callanan Avenue, you suspended the ability to rent to students only, not to everybody. They could have rented to a professional couple or 2 unrelated people who weren't students.
Yes.
Okay.
Yeah, he had 2 student rentals there, yeah.
And here, you suspended the license for renting to anybody. Property's got to be vacant till
Yeah.
April 11th of next year. And you testified that that was because of all the problems that the police had and the various and sundry other problems that occurred in addition to the more than 2 students living in the property.
Yeah.
Now, earlier in your testimony, when I asked you, you said that you had consulted. You didn't do this on your own. You consulted with the police and Mr. Daly and whoever else you said at the time, and then later on you said, but that didn't affect my decision. So my question now is, under the circumstances that you just cited, that the reason that you didn't suspend Callahan's rental privileges to anybody but students, and did hear that those factors did enter into your decision. Those other factors.
Those other factors.
Yeah. Well, which is it? Did they enter into it or didn't?
The specific reason was because they did not correct the zoning violation letter.
Which was
But the formal warning letter was issued based on the disruption that they caused in the neighborhood.
And when you refer to the zoning violation, you're referring to more than 2 unrelated persons occupying the property.
Yes.
So basically, the reason that you're doing what you did against the owners of 54 Garrett Avenue is the same as what criterion you used for the owner of Callanan Avenue, but in Callanan Avenue, you only suspended the right to rent to students, whereas here, you suspended the ability to rent to anybody.
Yes, I did.
Same circumstances, 2 different results.
No, the circumstances were not the same. The original circumstances were not the same.
Well, you said it was unrelated. It was the more than 2 unrelated.
The original reason I issued a formal warning letter to the owner of Callanan Avenue was for one reason: renting to more than 2 unrelated people. The reason for issuing the formal warning letter to this property was for the noise citations, the disruption to the neighborhood, and the too many unrelated.
But you just testified not 2 minutes ago that the reason that you suspended my client's ability to rent the property for 1 year was because of the zoning violation, that more than 2 unrelated people.
That was the item he did not correct. That's correct.
So then for the same reasons, you issued two different punishments. On the one hand, you only restricted the owner from renting to students. In this situation, you limited the owner to, or prevented the owner from renting to anybody for the same zoning violation.
I would say no, that's not the reason.
Well, you're backing and forth the whole time. You said that the reason that you...
I mean, he's answered this question, and he said that there's a difference between the two situations. He said there was more than student housing problems at this site. And Mr. Flail doesn't want to believe that.
Well, I'm not. Yeah, I don't want to. Without you characterizing or testifying, I mean, you have the right to ask him, and the board will decide whether he's going back and forth or not. But
he's right.
You may
to
not
a
like
degree.
his answer.
It's been asked and answered, but it's been asked and answered so inconsistently that I'm trying to get it clarified.
Well, I don't know if that's necessarily true or not. I think that's for the board to ultimately decide that. But you can ask him questions. I don't want you characterizing. What he's. You don't like his answers. That you may or may not like it. But the board will decide whether or not. They'll take it into consideration and apply it to his credibility.
At this point, I'll leave it as it is. I made my point. And that's all I have.
Thank you, Mr. Flail. Mr. Rice? Nothing else with this witness? Mr. Miller, thank you.
Thank you.
I have no other witnesses. I would move T1 through T15.
No other witnesses. Wait a minute. Let me confirm. Say that. Any other witnesses, and we move in our exhibits. I think there were just two, A1 and 2, but whatever
Correct.
they were.
So you're resting as well? Correct. Okay. Gentlemen, any closings? Do you want to hear? Well, it's up to you. I don't want to have you feel as if anyone wants to say anything more. We're not obligating you to. We don't want this to go any longer than it needs to, but you have the right.
Is the board going to make a decision tonight, or could we submit our closing in writing?
I don't want to bind them to this either right now. I want to give them a few minutes to collect their thoughts inside. If they're prepared to give you a decision tonight, I'll come right back out and let you know that it'll take a few minutes, but we'll be right back out.
The reason I was asking the question is I was posing whether it might not be better for everybody if we do our closing in writing instead of doing it here. If you're going to make the decision tonight, that's the question's moot. If you're not, why, that might be the better way to do it.
Well, what I'll do is the board's just heard you say that. They'll perhaps take that into consideration. Like I said, what I think, to be fair to everyone, is a rather lengthy hearing. Let them collect their thoughts. There won't be any deliberations going on other than them just trying to figure out what they heard, organize their notes. They're not going to be voting on anything. If they're going to if they're going to withhold their decision for another date, they have 15 days to make their decision on the ordinance. But they'll take into consideration what you just stated. Perhaps they would find that to be of some assistance. We'll let you know that relatively quickly after we go to the back room. If you gentlemen are done, we'd like to open it up if the public has anything. But before we do, I want to make sure you're both done. John? Okay. All right. All right. Mr. Chairman, if this time you'd like to just open it up to the public, if the public has any comments.
If anybody would like to step forward, make any comments at this time. Specific to this subject, house infractions.
Commissioner, if you could, because this is a hearing, if we could have you raise your right hand, you'll be sworn in by the court reporter. Actually, and John, gentlemen, do you need him up here for the public comment portion of this? Ed? I mean, that mic's on, I'm assuming, correct?
These are not parties, this is just.
Yeah, that's fine, as long as, good. You need to swear him in? If you could just identify yourself.
State your name, then, please.
John Fisher, Fisher. I'm the 7th Ward Commissioner. I represent roughly 5,000 residents of the 7th Ward. John Fisher, Commissioner of the 7th Ward. I represent the residents of Garrett Avenue, also all the neighboring residents, about 5,000 in all. Student housing can be a significant problem for the neighborhoods. It's been demonstrated over many decades now that student housing presents heartache for many residents because the students don't treat their neighborhoods the same way they would treat their own neighborhoods back at home. And in some cases, we have examples of landlords who do not accept their responsibility and maintain the properties in good condition. They also do not take on the responsibility of the tenants, in this case the students. And in many times, the students create major concerns and issues for the residents. We have students having parties late at night, on a work night when many residents have to get up the next morning and go to work. This is a very serious issue. I've been a commissioner for 5 years, and I would say about 20% of my time is related to student complaints and quality of life issues for the residents of my ward. We happen to have the highest density of housing, and with that, we have the highest density of students living in the neighborhoods. Not all students are bad. Not all landlords are bad. In some cases, the students and the landlords work very closely with the residents, and they do a good job. But there are many examples where that's not happening. It's in my opinion that this is an example where it's not happening the right way, where the students are not being good neighbors, where the landlord is not doing everything they can in their power under their ordinance, and also just out of dignity and out of respect to the neighborhood, they're not doing everything they need to do. So it's in my opinion that this rental license should be suspended. They have never shown over the 20-some years of their rentals at that property that they've taken on the full responsibility under the ordinance. And clearly the residents of Garrett Avenue deserve a peaceful existence. And this property in particular is not doing that. So thank you for hearing my comments.
Anybody else at this time? At this time, we'll close and take a few minutes to discuss everything that we've heard tonight.
voting to cancel.
At this time, we've decided to reconvene this meeting on the 26th of June. It'll be at 7 o'clock in police roll call room for anybody who's interested to attend. That'll give both parties a chance to provide their submissions to us in the next 15 days. At this time, that's all we have, and we thank everybody for their time. Thank you.